For the affidavit, we have filed.
I take the consent of the other subject. In this case, cinematography Viviga has been newly engaged also. We have received the file yesterday. Also.
Your name?
Our data. We have not filed our birth number yet.
You are for the respondent.
Petitioner. 2 weeks time will be allowed.
I put the respondent. 37.
37.
Yeah, the request of the Learned Council matters 21 Ministry of the Police. As per the direction of this Honorable Court, yesterday, Lordship, I have filed the additional appeal in respect of item number 21, Lordship, and it called for deeply of respect. That is, I think to mention item number 9, I pay for only 2 day accommodation. Without further action, it still added, which are we are unable to contact with our client. We are unable to contact with our client. Whether further action is still covered or not. What is the matter about? Loan lordship. The petitioner took a loan from the LIC. After he returned posted. But thereafter, LIC again demand because there is a pending. I have pending statement the petition. So then whether further action still has or not, I have to think. We vacate. There is a stay must be. No stay. I have taken consent from the LIC. Item number 9 after 4 weeks. Maybe item number 7 and 8, my lord. 7 and 8, stay HRM. Success in time or the event and vacated. Yeah, all the people who item number 27. By for 2 weeks time to file a affidavit in reply. Don't make that submission. But they have filed their affidavit in opposition. Don't make that submission. I won't allow them. Make documents. Think about a more better way. But some documents are required to be brought on record only for that purpose. Don't come up with that submission. Give a better submission, I will consider. That is the only ground for which I am taking adjournment. So no ground. Can't help it. Because if I give you time at the mentioning hours for affidavit, the question would be everybody have to give that, which I don't. But the only thing is that in this case, the issue is you got an interstate permit. That is also not on record. But if without that, maybe adjudication. Make a submission at the time when the matter is there. Okay.
Item 3, personal appearance.
Issue. One to keep. Person. Yes, you are the person. What is your name?
Your name is Sarang Brahma. Group Sarang Brahma.
You are the manager?
Yeah.
Now tell me one thing. Did the DFO
Yes.
call you
Yes, sir.
and ask you to print it?
Permanently, সেইদিনা মই ডিউটিত আছিলো নহয় 5টাৰ পৰা 6টালৈকে মই থাকো
হা?
5টাৰ পৰা 6টালৈকে মই অফিচত থাকো তো এতিয়া মানে হেৰি আছিলে মোৰ ইনচাৰ্জ আছে বাকী কাম কি চাই তাক মানে দায়িত্ব দি গলো তাৰপিছত মই ঘৰত গুচি গলো এতিয়া মানে এই ইনচাৰ্জ হেৰি আছে তেওঁ কি কৰিলে মানে নিজৰ ইমাৰ্জেঞ্চি কামত ইয়াত অকণমান টাইম বাহিৰত গুচি গ'লে আৰু তাৰপিছত সি চালে নিজৰ মোবাইল ফোনত এটা এডভাৰটাইজ মানে হেৰি থাকি গ'ল সেই থাকি যোৱাৰ কাৰণে মানে এই কিবা অফিচত যোনটো মানে আছে মানে যিটো কাম কৰি আছে সেইটো অফিচ ফোন কৰিলে মানে এটা এডভাৰটাইজ আহি আছে থাকি গৈছে এইটো মানে হেৰি কৰিব লাগে আপুনি অফিচত কোনোবাজনক আপুনি যোনটো হেৰি আছে
আপোনাক কোনে ক'লে?
হা?
আপোনাক কোনে ক'লে?
মই কোৱা নাই এই মানে য'ত মানুহে হেৰিতে কৰি দিলে আৰু
সেই মানুহজনক কৈছে? কোনে ফোন কৰিছিল?
মানে সিহঁতৰ লগত চিনা জানা আছে বুলি কৈ আছে
কোনে ফোন কৰিছিল?
এই হেৰি এই ইনচাৰ্জে মানে এই অফিচত কাম কৰা মানুহ এই বাহিৰত গৈছিলতো
হা।
তাৰপিছত এই অফিচৰ মানুহ ফোন কৰিছে এই অফিচৰ পৰা কনফাৰ্ম কৰিছিল এইটো কালি দিয়া যাব নে নাই এতিয়াতো টাইম হৈ গ'ল প্ৰিণ্টিঙত এতিয়া মানে অফিচৰ মানুহ হেৰি কৰিলে আৰু নহয় মানে এইটো কালি আৰ্জেঞ্চি দিবই লাগে এতিয়া মানে প্ৰিণ্ট কৰাটো এইটো আমি হেৰি কৰিলো আৰু ষ্টপ কৰি দিলোঁ তাৰপিছত প্ৰিণ্ট কৰাৰ কাৰণে এইটো আৰু আমি কিবা হেৰি প্ৰিণ্টিঙৰ কাৰণে আমি ৰিপ্ৰিণ্ট কৰিবৰ কাৰণে আমি এইটো প্ৰচেছ কৰিব লগা হ'ল এইটো ইনচাৰ্টেড কৰি
আপোনালোকৰ পেপাৰখনত এডিটৰ কেইটালৈকে থাকে?
এডিটৰ এইদিনা থাকে তথাপি এডভাৰ্টাইজ ছেকশ্যনটো বেলেগ নহয়
কেইটা বজালৈকে থাকে
এডিটৰ
অফিচত? সেইদিনা অফিচত কেইটালৈকে আছে?
এডিটৰটো থাকে এইটো আপোনাৰ 10টালৈকে থাকে কাৰণ তাত এডভাৰ্টাইজ ছেকশ্যন তাত দিয়া নহয় না
হা?
এডভাৰ্টাইজ ছেকশ্যনটো এডভাৰ্টাইজ মেনেজাৰে চাই
এডভাৰটাইজ মেনেজাৰে চাই।
এডিটৰটো নিউজ কৰি
তো
চাই
আপোনালোকে সেইটো এইবোৰ ষ্টেনচিল প্ৰিন্টিং হয়।
হা?
প্ৰথমতে এইটো আনি লয় প্ৰথমতে আপুনি এইটো পেজখন কেনেকে বনায়?
আমি কম্পিউটাৰটো এইবিলাক গোটেইকেইটা ছেটআপ কৰা হয়
হা?
কম্পিউটাৰ গোটেইকেইটা ছেটআপ কৰা হয় তাৰপিছত
তাৰপিছত?
আমি এইটো প্ৰিণ্ট আউট কৰি কিবা লেআউট কৰিব লাগে মাষ্টাৰ ওলোৱা লাগে মাষ্টাৰ ওলোৱাৰ ফ্লেট বনাব লাগে বহুত টাইম লাগে ফ্লেটৰ হিট দিব লাগে
তো সেই বস্তুখিনি কোনে কৰিলে? কাৰণ আপোনালোকে এই বস্তুটো 8:30টাৰ পিছতহে গম পাইছে। তো কোনে কৰিলে এইটো?
গম পাইছে মানে অফিচৰ মানুহ ফোন কৰিলে নহয়
কোন অফিচ?
পিএফৰ অফিচত মানে এইটো কিয় দিব লাগে নালাগে অফিচৰ মানুহ ফোন কৰিছিলে
অ
আমাৰ অফিচৰ পৰা এইকতে কোনোবা বেলেগ কৰিলে আৰু
কোনে কৰিলে?
অফিচত কাম কৰা মানুহ পিএফৰ অফিচত
কোনে কৰিলে? আপুনি একো নাজানাকে কেনেকে ক'লে? ইয়াত আপুনি লিখিছে as the printing of the paper, so he asks one of the staff to inform the client that in the office of the AR that the advertisement will get published one day later, but when contacted, inform the concerned on bid. আপুনি ইয়াত লিখিছে that the divisional forest officer ফোন কৰিছিল।
অফিচতে নিজে ডাইৰেক্ট কৰা নাই এই ষ্টাফত তৈরি কৰিলে
আপুনি তাৰমানে ইয়াত মিছা কথা লিখিছে।
না নহয় এইটোৱাই কৰি দিলে
আপুনি ছেকেণ্ড এফিডেভিটখনতো মিছা কথা লিখিছে যে ডিভিজনেল ফৰেষ্ট অফিচাৰে লেখা বুলি কৈছে যে আপুনি কৈছে বুলি কৈছে কিয় কৈছে? আপুনি ডিভিজন ফৰেষ্ট অফিচাৰৰ লগত আপোনাৰ কোনো কানেকশ্যন নাছিল।
এজন আছিল ছাৰ
তেতিয়া কোনে কৰিছে আপোনাক? আপুনি মেনেজাৰ, আপুনি 8:30 প্ৰিণ্টিং আৰম্ভ কৰিলে, প্ৰিণ্টিং চলি আছে, প্ৰিণ্টিং চলাৰ পিছত সেই বস্তুখিনি কোনে বনালে? আপোনাৰতো গোটেই ছেটআপটো বদলাব লাগিব সেই পেজ নম্বৰ 3খনত।
হয়তো ছাৰ এইটো পাছত মানে এইটো আমি প্ৰিণ্ট কৰিব দিলেই অলৰেডি
আপুনিতো প্ৰথমতে ক'লে সম্ভৱ নহ'ব অহাকালি কৰিম নেক্সট ডে, কিন্তু আপোনাৰ
আৰ্জেঞ্চি বুলি কৈ আছে ছাৰ
আৰ্জেঞ্চি কোনে ক'লে? মই সেইটো
অফিচৰ মানুহ কালি ওলাব লাগে
অফিচৰ মানুহে কৈছে নে ডিভিজনেল ফৰেষ্ট অফিচাৰে কৈছে? সেইটো বহুত ইম্পৰ্টেণ্ট বস্তু হয়। কোনে আপোনাক ক'লে? আপুনি নাজানাকে কৈছে নেকি এইটো?
মই এবচেণ্টত হৈ গৈছোঁ মোৰ এবচেণ্টত হৈ গৈছিলোঁ ষ্টাফে মানে
তো আপুনি এইটো নাজানে?
কাৰণে মানে
আপুনি নাজানাকে এইটো এফিডেভিট ফাইল কৰিছে নেকি হাইকোৰ্টত? আপুনি ইয়াত যোনটো কথা কৈছে যে ডিভিজনেল ফৰেষ্ট অফিচাৰে কৈছে যে এইটো কৰিব লাগে, আপুনি এইটো নাজানাকে কৈছে?
মোৰ এবচেণ্টত হৈবিলাক হ'ল না
এইটো এবচেঞ্চত হৈছে তাৰমানে আপুনি এফিডেভিট ফাইল কৰিছে আৰু নাজানাকে এফিডেভিট ফাইল কৰিছে। এইটো কেনেকে গম পালে? পেৰাগ্ৰাফ 6ৰ কথাটো কেনেকে গম পালে?
ষ্টাফে সিহঁতে হেৰি কৰিলে আৰু
কোনে ক'লে? হা? কোনে ক'লে paragraph 6 ৰ কথাটো আপোনাৰ matter of record or knowledge of বুলি লিখিছে but which part is knowledge and which part is record, Mr. Leroy? First of all, if it has to be a knowledge, then has to be his personal knowledge. Kindly see paragraph 6. As the printing of the paper has already started, so he asks one of the staff to inform the client that the office of the divisional forest officer that the advertisement will get published 1 day later. But when contacted and informed, the concerned divisional forest conveyed extreme urgency regarding publication of the advertisement in the next day's edition of the newspaper, that is on 9/12/2013. The officer reminded that while sending the advertisement to the newspaper in the evening hours of 8/12, it was made clear that the same had to be published on the next day. Because there is an absolute difference between this affidavit and the affidavit of the DFO. The DFO categorically says that he had no knowledge whatsoever, except he had given it to the publication of the director of publication, and thereafter the regional publication, they have done it. He doesn't know, he only came to learn when this court took up the matter. And when the director of the DIPR had informed this court and these orders were passed. And on the other hand, you are saying categorically out here that this particular officer called up and expressed extreme urgency to whom?
I'm reading it, my lord. The middle portion of the para 6, my lord, as
Yes.
the printing of the paper already,
Started. So he asked one of the
one of
staff.
staff,
So he must have asked his staff.
Yes.
And to convey that it is not possible on this day, we'll publish it on the next day. Then there is a statement which is of
Yes,
vital
I'm
relevance.
I'm coming to that.
Yes.
That's only correct. Printing of the paper already started, asked one of the staff of the inform the client. That is the office of the divisional forest officer that the advertisement will get published 1 day later. But when he contacted and informed the concerned divisional forest officer, conveyed extreme urgency. So the means, my lord, the staff, my lord.
That is not being mentioned out here. Because there is a apparent distinction. Divisional forest officer says, I have no knowledge. And he says that divisional forest officer conveyed extreme urgency. And you see the language of
I've read that.
concerned divisional forest officer. So you are specifically pointing it out to the divisional forest officer.
Staff, এইটো ভাল, এইটো পক্ষ। আপুনি DFO ৰ লগত কথা পাতিছে নে নাই? তাতে।
ফেমিলি DFO ৰ অফিচৰ লগত কথা পাতি ষ্টাফৰ লগত অফিচৰ পৰা এইটো ডাইৰেক্ট আমি ক'ব নোৱাৰো নহয়
Staff has spoken with the staff, with the staff of the division office. Staff of the division.
But here he is saying the concerned divisional forest officer. These are words used.
I'm thinking.
So you have categorically mentioned about a particular officer. You have pointed out to a particular officer. So now are you reciting from what you have stated in your affidavit?
আপনি এটা ভালকে পড়ি থাকুন, আপনি কত বুঝাবেন। কি করতে থাকুন। Pero lo que está pasando. তার মানে DFO ফোন করা হয়েছে সেইটো কোর্টে ছুটিছে আপনার আপনি DFO করিছে না তারপর DFO করিছে
আপুনি কিমান পঢ়া? How much? কিমান পঢ়া আপুনি? কিমান লৈকে পঢ়িছে আপুনি? গ্ৰেজুৱেট। গ্ৰেজুৱেট হয় আপুনি এখন ইংলিছখন বুজি পাব পাইছে নে নাই? এখন কি লেখা আছে?
বুজিছো
বুজি পাইছে? তেতিয়াহ'লে আপুনি ইয়াত কেটেগৰিকেলি আপুনি একদম স্পেচিফিকেলি লিখিছে নাই ডিভিজনেল ফৰেষ্ট অফিচাৰ মানুহজনে ফোন কৰি কৈছে যে এখন আৰ্জেঞ্চি আছে পাব্লিছ কৰিব লাগিব। কৈছে নাই ইয়াত? কি ভুল হৈছে? আপুনি ধেমালি পাইছে নেকি হাইকোৰ্টৰ কথা?
ডিভিজনেল ফরেস্ট অফিসার স্টাফকে ফোন করা হয়েছিল মই আণ্ডাৰষ্টেণ্ডিং
হা?
ডিভিজনেল প্ৰডিউচাৰক ফোন কৰা হৈছে যে কালিয়ে লাগে এইটো আমি কৈছো যে নেক্সট ডে
আপুনি কাক ফোন কৰিছে আপোনাৰ ষ্টাফে?
ডিভিজনেল ফৰেষ্ট অফিচাৰক
ফৰেষ্ট অফিচাৰক ফোন কৰিছে এই বস্তুটো put it on affidavit. Whom you called, the staff whom they have called, and who conveyed it specifically.
Particularly, printing secret, as one of the staff. Because of the, আপনার staff of the office of the deputy officer, that the addresses will get published on the newsletter, but when contacted inform the details of it, আপনি বলছেন the concerned regional forest officer conveyed extreme, so তার মানে এসব বলতে পারবে that extreme emergency আমার লাগে হয়ে যাবে। হ্যাঁ, তো এই থেকে কি মানে আপনি বলছেন এইটু হয় না একটু
ডিএফঅ'য়ে মানে কালিয়ে লাগে বুলি কোৱাৰ কাৰণে এইটো প্ৰিণ্ট কৰা হৈছে
কোনে কৈছে?
ডিএফঅ'য়ে ক'লে
DFO কৈছে তো, সেইটোৱে মই কথা কৈছো। Put this on affidavit properly. The staff called that the DFO and the DFO said this. দুই নম্বৰ কথা, আপুনি তেওঁলোকে স্পেচিফিকেলি কৈছে যে তেওঁলোকৰ যোনখন নিউজ পেপাৰ আছে তাত এই এডভাৰটাইজমেণ্টটো নাছিল। তেওঁলোকে যোনকেইখন পাইছিল, যোনখন আপুনি DPIৰত দিছে সেইখনত সেই এডভাৰটাইজমেণ্ট নাই। লেজিসলেটিভ এছেম্বলিত যোনখন দিছে সেই এডভাৰটাইজমেণ্ট নাই। আপুনি এতিয়া কথা কৈছে ইয়াত এফিডেভিটত যে 5,000 পেজ 5,000 প্ৰিণ্ট হৈ গৈছে আৰু বাকী 27,000ত আছে, হয়নে?
তাৰ মানে এইটো কি হৈছে এতিয়া আমি এইটো হেৰি কৰিলে নহয় যে আগতে এডভাৰ্টাইজ গোটেইকেইটা ইনচাৰ্টেড কৰা হয় ইনকৰ্পৰেটেড কৰা হয় পেপাৰত এইটো আমাৰ 8টাৰ পৰা 9:30লৈকে প্ৰিণ্টিং বা হেৰি হয় সেইটো প্ৰিণ্টত দিয়া হ'ল আগতো তেতিয়া 5,000 মান প্ৰিণ্ট হৈছে তেতিয়াহে সেই খবৰটো আহিলে তেতিয়া মানে আমাৰ এডভাৰ্টাইজাৰে এইটো প্ৰিণ্টিংটো ষ্টপ কৰিলে ষ্টপ কৰাৰ পিছত আমি আলোচনা সিহঁতে কৰি মানে এইটো কালি ওলাব লাগে হৈছে যেতিয়া এইটো মানে আমি ৰিচেট কৰি প্ৰিণ্টিঙত দিয়া হ'ল নেক্সট লট আৰু এইটো 5,000 আমাৰ ট্ৰান্সপৰ্টৰ টাইম হ'ল ট্ৰান্সপৰ্ট আহি গ'ল তেতিয়া গুৱাহাটী আমি বাহিৰত আহি পেলাই দিব লগা হয় আৰু নেক্সট হ'লে আমাৰ 2-3 আৱাৰ্ছ আমি লেট হৈ যায় চাৰ্কুলেশ্যনটো আমাৰ এফেক্ট কৰে সেইটো কাৰণে আমি এইটো আৰু উইদাউট এডভাইচ NIT নোহোৱা সেইটো ৰিজনেল প্ৰডাক্ট সেইটো আমি চাৰ্কুলেশ্যন পাবলিক দিয়া হ'ল
আপোনালোকৰ ডেইলি চেল কিমান হয় পেপাৰ?
ৰিলিজৰ আমিতো প্ৰিণ্ট কৰোঁ 32,000
কিমান প্ৰিণ্ট হয়, কিমান চেল হয়?
তেলটো আমাৰ এই হেৰি হয় আৰু 25,000 30,000 কেতিয়াবা এনেকুৱা মানে এইটো আপ ডাউন হৈ থাকে
চেলটো কেনেকে হয়?
তেলটো আমাৰ অকল এইটো বড়ো কমিউনিটিয়ে চাইছে অকল মানে বড়ো কমিউনিটি বড়োবিলাকহে পৰে বেলেগ কাষ্টমাৰটো পঢ়িবই নোৱাৰে বেলেগ কাষ্টমাৰটো পঢ়িবই নোৱাৰে পঢ়িও বুজিব নোৱাৰে তেনেকৈ আৰু আমাৰ বেছিভাগে আমাৰ তেতিয়াৰ
বড়োলেণ্ডত কিমানখিনি আছে আপোনাৰ ইয়াত নিউজ পেপাৰ কেইখন আছে তাহাঁতৰ?
কোনে কোন আৰু দুখন 3খন আছে
আৰু আপোনালোকৰ সবচে বেছি পাব্লিকেশ্যন?
আমাৰটোৱে চবচে পুৰাণা
হা?
আমাৰটোৱে চবতকে পুৰাণা ফটোস্থাটো
আপোনালোকে পেপাৰ যে আপলোড কৰিলে ই পেপাৰখন
হয়।
সেইখনত কাৰেকশ্যন নহ'ল কেনেকে?
সেইটোতো হোৱা নাই আমি যিটো সেইটো পাৰ্টছ আমি যিটো এডভাৰ্টাইজ সেইটো NIT নোহোৱাকৈ আমি এইটো পাৰ্টছ সেইটো তেতিয়া সেইটো পঠাই দিছোঁ তাৰপিছত আমি নেক্সট সেইটো পঠাই দিছিলোঁ
আপুনি আপলোড কেতিয়া কৰে?
আমি যেতিয়া প্ৰিণ্ট আউট কৰাৰ পিছত প্ৰিণ্ট আউট কৰিব দিওঁ নহয় তাৰপিছতে আমি এই কিবা ডিটেইলছ আউটচৰ্চিঙত কৰা হয় বাহিৰৰ মানুহ দিয়া হয় PDFটো অনলাইনত লগাই দিয়ে
অনলাইনত কেতিয়া লগায়?
আমি সেইদিনাই লগাই দিয়ে
কেতিয়া?
কেতিয়াবা
আগদিনাটো নলগায়?
হা?
আগদিনাটো নলগায়? আপুনি
Next
আগদিনা
day
ৰাতি কৰে নেকি? আগদিনা ৰাতি কৰে নেকি 8:30 বজাত?
তেনেকেই কৰে
8:30 আপুনি ক'ব বিচাৰিছে যে আজি 8:30 বজাত আপোনালোকে আপলোড কৰিব আজি পেপাৰ অহাকালি পেপাৰখন?
নকৰে কালিহে কৰিম না
অহাকালি কৰিব নেক্সট ডে? ইন দ্য মিন টাইম আপোনাৰ কাৰেকশ্যনটো হৈ গৈছে।
এতিয়া আমি দিছিলো এইটো আমি এইটো লগাইছে আমি ক্ৰক্স কাৰেকশ্যন আমি চোৱা হোৱা নাই আৰু
কোনে চোৱা নাই?
চোৱা নাই, এইটো
আপুনি চোৱা নাই মানে কোনে চোৱা নাই?
মানে নেক্সট টাইম হেৰি বহুত কামত ব্যস্ত থাকোতো
হা?
তো আমি নেক্সটটো আমি বিজেপি চোৱা হোৱা নাই আৰু
কোনে চোৱা নাই?
চোৱা হোৱা নাই
আপুনি চোৱা নাই?
তাকো কৈছিলো আমি বিজেপি হৈ পাঁচ লতো সেইটো বিজেপি লগাই দিলে
তো এই আপলোড কৰা যোনটো অনলাইন কৰে সেইটো কোনে চাই? আপোনালোকৰ
বাহিৰত মানুহ
হা?
বাহিৰত মানুহ আমাৰ চিষ্টেম নহয় আমি তাক মানে তাক কিবা এটা কুইজ দিওঁতো
কাক দিয়ে?
মানুহ আছে আমাৰ
কাক? আপুনি কোৰ্টত আছে গম পাইছে নাই? আপুনি মানুহ আছে মানে কি মানুহ আছে? আপুনি ধেমালি পাইছে নেকি?
ধেমালি পাবা নাই নাম আমি গেটত বসুমতাৰী বুলি এজন আছে
হা?
গেটত বসুমতাৰী বুলি এজন আছে তাক দি আৰু
কেতিয়া দিছে?
তো
সদায় সদায় আপুনিতো মেনেজাৰ হয়, কেতিয়া দিয়ে?
এইটো আমাৰ যিটো প্ৰিণ্ট যিটো প্ৰিণ্ট হয় প্ৰিণ্ট পঠাই দিলে আৰু এটা তাক পিডিএফ পঠাই দিলে
অনলাইন কৰিবলৈ কেতিয়া দিয়ে?
আমাৰ যিটো গোটেইকেইটা ছেটআপ হোৱা ডিসপ্লে দিয়া হয়
I think the best way is to send him to Lokhra. There's no way out. I think we have the security out here, no? We get him arrested and put him behind bars. I think get it out there with something. We initiate contempt proceedings against him for making.
There is total contradictory.
Yes, there is contradiction.
Paragraph 4 of page 91. Paragraph 4 of page 91. See what statement he has made.
He has taken it for guide. Yeah, so we.
What,
I think it is the best way we put him behind here. In the
what statement he has made in paragraph 4? Lordship has seen, and today, paragraph 6, see paragraph 4. See his first statement. And what at page 122?
No, I
Lordship
wanted
is asking-
actually I wanted to hear him only for a purpose. As regards the involvement of the divisional forest officer, because the divisional forest officer categorically states that he had no knowledge. Now he says that he has knowledge and his staff, which he doesn't name, has contacted him and specifically talked with the divisional forest officer. If that be so, then I think why we should not initiate 340 proceedings against him, against the divisional forest officer, and further direct he will be under the forest department. The divisional forest officer would be under whom? So he was on deputation. He was on deputation, huh? Panjabari by BTC. Assam.
So reference he was placed.
So I think he is under the Assam Forest Cadre. No, here there was a specific direction given as per him that the DFO has categorically stated before this court that he has not done it. Whereas he specifically states in his affidavit that the DFO has done it. But there is two contradictory stands of the DFO as well as him. And how will this court decide that? Why we should not ask the RNI to close their newspaper? Get me the RNI Act. We should immediately close their newspaper. Because these type of fraudulent persons are there in these type of newspapers, we should be closing. We should issue notice to them. Close their newspaper. That is the way out. Because if these frauds are being committed by these people,
তার মানে আমার এই যে আগুন কিবা হলো
আপোনালোকৰ নিউজপেপাৰখন বন্ধ কৰি দিম এতিয়া। এইটোৱে।
এটাকে নতুন কথা
না 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 এইটো আপুনি মিছা কথা কৈ আছে সব কথাতে আপুনি মিছা কথা ক'ব নোৱাৰে আপুনি মিছা কথা কৈছে এফালে এফালে আপুনি কৈ আছে ডিএফও লগত কথা পাতিছো ডিএফও লগত আপুনি কথা পাতা নাই আপুনি যোনটো ষ্টেটমেন্ট দিছে সেইটো আপোনাৰ কনসিকুৱেন্স গম পায় নাপায় কাৰণ এতিয়া কোৰ্টে আজি অৰ্ডাৰ দিব ডিএফওক সাসপেন্ড কৰিব পাৰে তো ডিএফওক যদি সাসপেন্ড হয় আপুনি যদি আপোনাৰ কথাটো বদলি আছে এফালে আগতে কথা কৈছে নাই কোনো পাব্লিকেশন হোৱাই নাই মিছা কথা এওঁলোকে কৈছে আমাৰ নিউজপেপাৰত কোনো টেন্ডাৰ নোটিছ হোৱা নাই আপুনি কৈছে হ'বই নোৱাৰে এতিয়া আপুনি বেলেগ কথা ক'ব আহিছে যে মোৰ 5,000 হৈ গৈছে তাৰপিছত 32,000 আৰু 27,000 খনত এয়া নাই আপলোড কৰোঁতে আপুনি সেইটো কৰা নাই আপলোড কৰা যোনখন নিউজপেপাৰ আছে সেইখনত একো কৰা নাই তো এনেকুৱা নিউজপেপাৰ আপুনি কেনেকৈ চলিব দিব লাগে উইল আস্ক দ্য ৰেজিষ্টাৰ অফ নিউজপেপাৰ্ছ to make an inquiry against Akon this newspaper and whether this can be allowed to survive. We make the RNI a part. Who will appear for the union? Union, you are there? Anybody? Yes, madam. Union. We make the register of newspaper a part. And we pass an order to that effect, whereby we ask the register in newspaper to make an inquiry as regards what is there, and if necessary, to suspend this newspaper. I think this is the best thing. Because you have the power to grant the permission. The running of a newspaper has to be on the basis of this. So if they are resorting to all falsehood and thereby having effect to the public in general, I think it's high time their newspaper should be struck off. Their license, what is it? There is a particular permission, approval, or permission is to be given under the RNI by the register of newspapers, newspapers and something. So they are to give the permission. So that permission, I think we should remove it from them so that they can't go ahead and print. Or printing bondo is up.
তেনেকে নকৰিলে ভাল হ'ব নেকি স্যার?
না নিউজপেপাৰখন বন্ধ কৰিব লাগিব দেখক pursuant to the order dated 4/11/2024 pursuant to the orders dated 26/9/2024 and 4/11/2024 Mr. Rupswarang Brahma, who claims to be the manager of the newspaper Sanseri Bodosa, is present before the court. During the interaction, this court inquired with the said person as regards the veracity of the statements made in his affidavit filed on 29/9/2024, as well as the affidavit dated 30/5/2024, as both are apparently contradictory in nature. It is also seen from the said affidavit, more particularly at paragraph number 6, as well as the affidavit filed by the divisional forest officer on 19/9/2024, that there are apparent contradictions. Inasmuch as in the affidavit which have been filed by the divisional forest officer, he had completely denied having any interaction with any person or staff of the newspaper Sansari Budosa. Whereas at paragraph number 6 of the affidavit filed by Mr. Rupswarang Brahmo on 23/9/2024, it appears that the concerned divisional forest officer conveyed extreme urgency regarding publication of the said advertisement in the next day's edition of the newspaper, that is on 9/12/2023, and the very officer reminded while sending the advertisement to the newspaper's office in the evening of 8/12/2023. And he made it clear that the same has to be published on the next day. Taking into account the contradictory stance, this court, before passing appropriate directions for initiation of any action against the concerned DFO, as well as the respondent number, as well as the respondent number 11, including Sri Rupswarang Brahmo, finds it appropriate that a chance be given to an opportunity being given to the DFO to explain. Accordingly, Mr. Ranjit Kaur, who was the then DFO, of the Parbotjora Division, Suparighat, Boroland Territorial Council, is directed to file an affidavit before this court explaining the said contradictions. First, in addition to that, this court also this court also grants liberty to the respondent number 11 to explain by way of an affidavit as to why directions should not be issued for appropriate investigation by the Register of Newspapers and
Paper of India, RNI. Register of newspaper of India.
investigation should not be carried out. Direction should not be issued for investigations being carried out by the Register of Newspapers of India, for India, bracket RNI, in respect to their alleged, in respect to the working of the said newspaper. List this matter again on 27th of November 2024. Mr. R.R. Gogoi, who is the officer, who is the standing counsel of the Forest Department, shall duly communicate the instant order to Mr. Ranjit Kaur, who is presently working, who is presently working and in his departments, in the Forest Department. 2711, no?
27.
Next time, Apnar, yeah, Mr. Roy, can you explain it to your client to that effect? Next time, what I propose to do is, once I found that there is no good ground, we will send it to the RNI for RIA. And he would be then, I'll initiate 340%. On the, apparently, what he says is, he has just come to say many things out there, which is absolutely false. He's only trying to hide his mistake. So we'll initiate 340 proceedings against him. I wanted to say as to whether 340 proceedings can be launched against the DFO also. Once I found out, then it will go for both. And then criminal proceedings, suspension, disciplinary proceedings, termination.
I'm just looking to it, that's a, press, the registration, registrar of so and so. There is a provision, which are finding it out. What is the step they can take? Because there is a provision that are just criminalized and there is a provision for giving a correct, wrong information. Just we look into it for the.
But I think there, in fact, they can revoke the permission. Once it is revoked, they cannot publish. I think these type of newspapers should be shut down immediately, forthwith. But I'm giving them the chance out there to, yeah, because tomorrow they may question that we are not given an opportunity. And this person seems to be not, doesn't know head or tail anything about it. It's just person who have been. Let it be filed by some person who is the owner of.
But this is one of the instances. There are other instances of this court which I practically dealt. I know there are same in fishery also where this publication was given. It was called for.
No, therefore,
we
will consider. Available. On the next day, this court will also hear as to what appropriate, also here, taking into account the would also hear as to whether any appropriate guidelines can be issued, taking into account the admitted illegalities which were committed in the instant proceedings pertaining to the publication in the newspaper.
Item 1, top of the list.
So there is a case during the subsistence of injunctive order, proceeding 337 is thrown out.
Oh, this one.
So just look for more 337 for now. 337 for.
Now, first, let us, we want to finish it off. Oh, GMC.
GMC.
Don't worry.
Notice below.
I am already 75% in your favor.
Then I'm sure.
Make another 25%.
Then I'm not let's say I'm not in danger zone right now.
Huh?
I'm not in danger zone right now. No,
Yeah,
this is
I'm
one thing,
already
very important, 337 4 section.
Let us first see what is your case about.
My case is that, my lord, initially they issued a notice 10/5/2020 asking certain document. Authority we have put under challenge. Stay order was granted. Afterward, permission was, NOC was granted in our favor on, my lord, 7/10/2024, 7/10/2024. And finally, my lord, 29/10/2024, they contemplate the proceeding under section 237. Now 337 for demands, my lord, that if a plan has been approved, this 337 cannot be invoked, and this issue has been dealt with by this honorable court, honorable Justice Ansari's judgment is there. It is confirmed that it is, my lord, very proper. My lord, may I please,
So you did not have any permission.
my lord, initially I don't have permission.
So you constructed a building.
That was earlier.
Hear me. You constructed,
Yes.
whoever it is, the building was constructed without any permission.
Absolutely.
But thereafter, you got the permission
Yes, my lord.
on 10/7/2024,
7 10, my lord.
7/10/2024. And 22 days later, they issued the 337. This is your
Yes,
intent.
exactly.
Why the first repetition? This is for the IA. I'm saying why the repetition was.
My lord, initially, well, what happened, lordship, can you see the read petition? Initially, they have issued us a notice at the instance of my rivalry party, and it was issued by, my lord, one of the assistant associate planner, my lord.
Then
That authority doesn't have, my lord, under GMC Act.
Huh?
Page 29. Read petition, page 29.
so asking you for documents is also bad.
Yes, my lord.
Why?
My lord, reason behind it that, my lord, one of the Samir Chaudhary, who is the rivalry party of us, my lord, he had put a complaint about our construction.
So what? He's asking you a document.
But
What is
that
wrong
cannot-
with you?
but it is the initiation of contemplation of 337 and 337.
Initiation of 337 will be done as per law, which is
Exactly,
already
my-
provided out there.
My lord, the authority is in question. My lord, the person suppose assistant town planner issued a notice. Notice. This power cannot be
No,
decentralized.
no, but this is high time. This type of repetition should have been dismissed on the first day. I would not have even dared to issue the notice in this. Forget about the state. Let us see.
Notice 337 4, my lord.
Forget 337/4 is different. We
Yes,
consider that
quite right.
which is there in the IA.
Quite right.
That is also subject to another.
Quite right.
First of all, power to require removal or alteration not if any building is erected or erected in contravention of 222 or and may without.
My lord, may I put 37 section, my lord.
If the judgment of Justice Ansari
Yes.
pertains to plans being pertains to plans being approved after construction.
Yes, sir. Yes, sir. Yes, sir. That is the, but 337, my lord, because my plan has been approved. Now suppose deviation is there, taking that way, my lord. It is not a case of unauthorized, madam. It's a irregular construction that can be regularized, madam. Once we carry out the construction, we'll adjust the situation. The concerned field officer may inspect, madam.
But here the facts is not clear, na?
And the little bit not similarly not, but question is that, my lord, in a case of irregular, will regularize, my lord.
Now, where, here, I think 337 4 will apply where plans were approved. It shall not be open to the commissioner to give such notice on the ground that the building contravenes any building bylaws as the case may be, or does not comply with the requirements under the park.
I think, my lord, think that there are two distinction. One is illegal and one is, my lord, unauthorized, my lord. That's why, my lord, if plan is approved, my lord, subsequent any deviation there, then they could, my lord, give us a.
First of all, your requisition is devoid of any merit.
Well, can you see, section 37 debars to decentralized power, madam.
What?
Section 37 debars to decentralize the power in respect to 337, madam. DMCA. And, my lord, it is the contemplation of 337 because initially the assistant associate planner is supposed issued a notice, my lord, which is nowhere, my lord, reflected in the GMC Act, my lord. Then anybody can issue notice, my lord. It is headed by the commissioner, my lord. Suppose if any notice required to be issued, take it for a moment. How a assistant associate planner can issue a notice under what authority of law, number one. And number two, under inviting what provision of
Who
law?
can issue the notice?
Associate planner, my lord. Assistant associate planner, my lord.
Who can issue notice?
My lord, because under 337, only
It is
commissioner
not a
of
335 action.
forget about 337, my lord. Suppose if the, my lord, otherwise, my lord, it has to be issued by the, my lord, commissioner because he's the head of the department of the corporation. Or, my lord, take it for a moment. Associate planner is the head of the building section, my lord. But assistant associate planner, my lord, why he step in into that power, my lord? And question is that, that's why, my lord, this one will put a question to them last weekend, that under what power he deserved to issue such kind of notice, they failed to answer before this one. So, therefore, my lord, so far 10-5 is
He is
concerned,
asking for, what is the role of an assistant
my
town
lord,
planner?
my lord, not a notice, this is later, my lord. My lord, notice
What is the role of an assistant town planner?
but nothing, my lord, it's just like an engineer, my lord. He suppose there are so many, my lord, assistant associate engineers are there, my lord, headed by associate engineers. They are pre-commissioner, my lord.
You may not respond to this
My lord,
document.
that's why, my lord, question is that, my lord,
If you think that he is not, has nothing to do, show me who can issue a
my lord,
notice. Can you show me that it is only the
my lord,
commissioner who is?
this, my lord, burden cast upon the,
No.
my lord, there is no, my lord,
Asking for, you see, the court is,
Commissioner, my lord, nobody-
not going to exercise the jurisdiction unnecessarily.
My lord.
You are asking for a writ of sorcery. A writ of sorcery is not to be issued just for the sake of it.
My lord.
We issue it when we feel like. It is an absolute discretionary when it is necessary. You have been asked for certain documents, go and submit
My
the
lord, that-
documents. If you don't submit,
my lord,
then 337 one notice will go.
my
Then
lord,
go and reply.
yes, ma'am, 337, my lord, kindly see that is us, now the subsequent event has not changed, my lord. That two changes are there. Number one, my lord, we have got the problem.
In fact, this has become useless.
Yes, ma'am, yes, quite right, my lord.
As of now, it has become useless
Exactly, ma'am,
because of
exactly, because-
337 one being issued where you have replied.
But
So how does this have any value? Reprision has become instruction. If the reprision has become instruction, how do I take care of the other second one?
I, the subsequent development, my lord, Lordship cannot,
Subsequent, I mean,
my
by
lord,
way of a writ.
Lordship definitely do justice with us, my lord. If you have come with a fresh repetition. No, my lord, Lordship, only one point is, only one point, my lord. Only one point, my lord. Lordship,
The permission.
I have for,
There is a permission.
I have for a point,
There is a permission, page number 27.
Number?
It says they have got a permission on 7/10/2024. This is under a scheme. by the way. The permission can be taken out online under a scheme. On the date of application, we made the application when it comes by through an RTI. So no, my lord, registered technical person of the GMC. He makes a scheme. He makes it that another scheme. He makes a online application. The online ticket fee, he gets a permission. Immediately he has got a permission. But in fact, this person, registered technical person, has never visited the spot because already there is a.
So
building there.
nowadays, AMC commission, you can
C
just,
plus.
Huh?
C plus. This is under a scheme called. There is a scheme. my lord.
Mukhyamantri,
Mukhyamantri.
Sahaj
Yes,
Griha
Mukhyamantri Sahaj Yojana
Nirmal.
So-
Nirmal.
anybody can go there, apply.
Apply through an
register technical person, there is a particular formula in there that app that the thing is there. It fits in, then we get the permission immediately. But this person may not have edited the spot because there's already a building. This person he is getting a new building permission, and he has not visited the spot. The building is already one building is already there. The sitting in the office, this online permission will take.
See, there are internal management that how that and but we with on record manner we have a permission. Why they have not visited or visited manner these are not.
It is RTP is chosen by the petitioner itself. There are multiple RTPs. There is, if the technical person of GMC, there are multiple, they are registered. And they have a choice of selecting the particular artist. They have taken a choice of the Mr. So-and-so of that particular RTP. And he has done it. RTP's name is there in the copy too. There, down below in page number 27, down below my lord. He is the person who has taken out the registered this permission. Copy 2, number 2.
So you got this permission
Online.
prior to that.
Under the key. Online license, so you can take out everything has been made easier. Ease of doing business. And in the ease of doing business, you have visited that particular spot where the land is there. And already a building is there. Without any.
So it's a very strange thing. When you see Annexure 2 of the IA, a notice asking for documents was served by demand dated so and so. In response to the notice, we have submitted a reply on 17/5, but failed to submit the NOC. The site has been visited by so and so. On inspection at site, it has been found that some deviations in the setbacks. Hence, notice under is now prepared. You are therefore directed to discontinue the undertaken works of which at your cost and so forth within 7 days while the unauthorized construction should be demolished.
So in the meantime,
How can there be a setback violation? If it is a case, there is no permission, where is this?
there can be setback violation in the thing that if a building stands, it stands even without NOC. It has to stand there as per the building bylaw. Then you can take out regularize it. But it has to stand as per the building bylaw. So as per building bylaw, there is a violation. NOC is not there, but still you can regularize it if there is as per the building bylaws. You make an application under section 18 of the building bylaws, the building bylaws 2018, then we'll calculate it, pay the penalty, take a NOC and get this building regularized. Here the person has not done, so there is no NOC. Here the person that has not done. He takes out another NOC.
So are you saying that without permission, a building can stand?
If that NOC you have to demolish it, but still they can file an application. The building will certain person may be as per the law. Then they can
So meaning thereby that without permission, there can be a building. Correct.
without permission there cannot be a building, but if the building makes a there is setback violation, means pay the penalty regular
Setback is different. Setback will only come when there is a permission.
permission. But
But where is the permission?
permission is not there. You
If the permission is not there, then can there be a setback violation?
no, there cannot. The permission is not there. But when the measure is that building, every building can be constructed. But building is not standing as per building bylaw because there is building bylaws meaning that without NOC it is standing. But still, if we have granted the NOC, there is also that.
NOC, so did you consider the NOC in the
No, there is no NOC.
Therefore, I'm saying, how can there be a setback violation? Are you therefore suggesting that irrespective of whatever means, we are going to give you you don't need to take a permission, but then also, if the building is standing out there, we will only consider if there is any violation to the building bylaws. The effect as regards setback and the height and all. But we are not going to look into the question of the NOC.
NOC, because you have to make an application, saying that this is the NOC is not there, we regularize the.
What is
building
your
as per-
building size?
As per building bylaw.
Our building size, standing over 5 lectures.
What is your building size?
C+2, small building, just 170 unit size there.
T+2 in 5 liters.
Yes, it's an old building. Now, thing is that we have one cut of 5 lectures. Now, suppose the major portion is vacant. Now, that's why we ask for permission. Once that permission we have granted, madam, we start the construction taking for moment. And whatever is structure existing there, madam, we'll adjust it. Suppose and thereafter, madam, we'll inevitably visit there because we have to obtain occupancy certificate. But why there is a dismantle required, madam? I don't feel, madam, we on state, madam, the children are, madam, appearing for examination, madam, in the month of February, madam. They have to see, madam. Equity is also demand.
But as per 337(1), you don't pull down. You pull down on the
If you pull down,
337(3).
if there is a application comes, then you have to consider it, there in section 18 of the building bylaw, if the application comes. There's that, yes, my building is without NOC, then I will make it as per the building bylaw of the particular year. Then you can consider it, because there is one case. That is from Udan Bazar, that is Pulogo.
Are you telling me
Both
that
has
the
allowed.
building bylaws which have been made now, compared to the building act, the GMC Act? The building bylaws are made under the GMC Act. But can it go, because the GMC Act, the GMC Act categorically mandate the requirement of an NOC.
NOC is there.
If that be so, how the building bylaws can say that without building NOC also, you'll only look into the question of the setbacks or anything.
Let them apply, well, they will consider them then, because there is one case where
I mean,
they have to apply for regularization under section 18, because we have to say that
can you
there is no,
regularize,
there is no.
can you regularize the building which is being constructed beyond, without the permission?
But that provision is there, madam, under bylaws.
Section 18, there is a section 18, you have to make an apply for the regularization. That particular,
Regularization is compounding.
yes,
There's
that
no
is,
regularization concept. What is it? We are not looking into a job business. Where is the question of regularization? Let us see where it is. Building bylaws.
Section 18.
section 18 of the, no, there is no building bylaws, that is the old book, this is the new one.
No, these building bylaws cannot.
But there is,
You hold the
Because the-
building bylaws to be bad.
another big building bylaw is there in the.
You hold the building bylaws to be bad. It cannot go. The building bylaws cannot go beyond the statute. Here it says that there is a requirement to take permission.
Yes, there is a requirement of section.
Ground on which permission to erect may be refused. Now kindly see 330. So every person who intends to erect or re-erect a building shall submit to the corporation an application. Every plan or area which is constructed only or partly originally submitted shall be in token of it having fair as per year every document prepared by the commissioner on the advisory shall refuse to sanction the erection of the erection. Commissioner on the advisory may refuse to approve which it is intended to erect it. If any building is erected or re-erected in contravention of any development scheme mentioned in 330 or any building bylaws made under 403 or without plans have been deposited or notwithstanding the rejection of plans or otherwise therein Commissioner may without prejudice to his right to take. Where is the power to compound?
My lord, that contained in my lord appendix 3.
The act.
It is under that building bylaws.
No. First of all, the power to compound.
Yes, page number,
Power to compound somewhere
page number 3, look.
by way of building bylaws.
Page number 3.
Without permission also one can make. You file an affidavit.
Fine, second.
No, you file an affidavit that without permission also one can erect and then only you are going to look into the subject. Huh? No. This is going to be helpful for others also.
This is what the
So file an affidavit.
one, under the second ballot, he got an NOC to construct a building. Ultimately found out that the NOC
You see what?
was supplied by someone, thought it is a genuine and something. He is one of the,
One of the?
They reported case.
Right.
Then
Then what happened?
the building.
2007 matter.
Then the, it went to the building letter, 2007 went for letter. It state that if the building stands and wood portion which have in violation of the building bylaw, that be demolished. If demolish the building, it stands. That portion has been done. Which it cannot stand in violation, it stands without in violation of the
But isn't that goes against the act?
bylaw. That is the law, and that was the.
That must have been done in exercise of the powers under 226. Have done. I may not have the privilege, exercise of a discretionary jurisdiction is done in a bird. That is not binding on us.
That was a fake NOC, with a fake NOC contracted.
So this will be allowing both the GMC.
That will be another chaos.
No, this is not only care, this is allow both the GMC own muscle. And to two, pick and choose.
Yes.
That in this case, we are going
It is
to.
bad. My lord, last
That-
application
that-
was like mentioned 7-story building file was missing, my lord. Here, my lord,
That
5.
is why it is happening. You exercise your discretion in this manner.
Yes,
This
my
is
lord,
why
appreciate it.
You file an affidavit. There is GMC without by building bylaws also, without a permission also, it's not abolished.
Right.
You see? But this is a very vital issue. Then in all cases will pass. The 337 cannot be.
Let me. So, that in that case I have feared that particular.
For you, we hold your requisition to be in success now. The stay order to continue for 7 days, giving you permission to file a fresh requisition. But I think this is a better, option. Because with this high, you cannot survive.
My lord,
Because your requisition is becoming.
yes, my lord, because events got changed. My lord.
Even we need to act.
But it's a legal point, my lord, 337, my lord. He suppose Lordship has pointed out.
Because I cannot pass that
Even my
order.
lord, the engineer are confused that suppose this is the situation. Sometimes suppose a person apply for that, my lord, like this construction. They want to say that.
No, another thing is. Yes. Why the building bylaws as well as this act has not been amended before coming into that
Hello.
you can get an online permission. It will have a far-reaching effect.
So we are facing the same problem in the trade line.
Trade license is okay, but it may not have any
Moment
so
they get
much
a notice.
impact, but this is going to infect the public. Anybody can make a G
Online,
plus
online.
two
This is
in
another-
any
another-
area.
Any unauthorized construction can be
Because
developed.
this-
And what about the park? There's no concern of any farm with this, G plus two.
There will be a farm, my lord, because this is a scheme, my lord, the scheme is this has been done, because it is a, he cannot, there's a scheme, my lord, you have to put the diagram and everything online, then it gets approved online. You have to do it as per the.
Because his application is of 710, he gets the permission shortly at 710.
Within minute you will get it.
Yes.
Within minute.
And ultimately, I have been saying, God,
Because how are you doing it without amending the act?
Yes, that's the issue, my lord. Online trade license, my lord, the moment they get a notice, my lord, in one AM, they get that trade license. This is the online, there is,
Like the GMC at 1 AM also demolishes somebody's building. GMC also demolishes somebody's building at 1 AM. 1 PM.
yes, that night, that, that
I-
become viral, my lord.
one AM, because demolishing a building is a very tedious job, because you have to engage the district administration fully, then the.
Which you don't do. They just go and pick up. Take the excavators, break it
The
away.
excavator is a very costly affair, my lord. Now, then after realize the amount from the illegal builder, my lord.
Tell them. Therefore, I. The, you had Mr. S. Samaria, the learned counsel appearing on behalf of the petitioner, and Mr. S. Bora appearing on behalf of the GMC. The present petition has been filed challenging a notice dated 13/5/2024 by the assistant town planner, whereby the petitioners were asked for certain documents. It is seen that pursuant to the said notice, various subsequent events have taken place in as much as there is a further order being issued on 29/10/2024. Under such circumstances, nothing further remains in the writ petition for which the writ petition stands closed as infructuous. I heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. So-and applicant and Mr. So-and-so. The petitioners herein are the writ petitioners, applicants herein are the writ petitioners in the petition number 2790 of 2024, which have already been closed as it had become infructuous in view of certain subsequent events. Be that as it may, it is very pertinent to take note of that pursuant to the notice which was subject matter of challenge, notice dated about the question mark, notice which was the subject matter of challenge in deputation number 2790 of 2024. The petitioner herein, the applicants herein had applied for permission on 7/10/2024. And on the very day, the no objection certificate for construction had been issued from the office of the Guwahati Municipal Corporation. Be that as it may, the Commissioner GMC had issued a notice on 337 under 337(1) and 2 of the GMC Act 1971. On the ground that the petitioner applicants failed to submit the NOC and the approved plan for the construction. But pursuant to the said notice, the the applicant submitted a reply on 4/11/2024. stating inter alia that the applicants have been accorded the permission on 7/10/2024. And as such, requested the Commissioner GMC not to further to drop the said proceedings. However, taking into account, apprehending that action should be initiated under section 337(3) of the GMC Act, the instant application was filed seeking certain interim protective measures. Mr. S. Samari, the learned counsel appearing on behalf of the applicant submitted that once there is already a permission on 7/10/2024, the entire proceeding sought to be initiated by the notice dated 29/10/2024 is contrary to the provision of section 337(4) of the Act of 1971. He therefore submitted that such proceedings so initiated by the notice dated 29/10/2024 is on the face of it without jurisdiction and authority, and in that regard had referred to a judgment of the in the case of T.R. Kapoor versus GMC and others reported in 1988 GLR 239. Mr. Espora, the learned counsel appearing on behalf of the petitioner, respondent GMC submitted that a notice dated 29/10/2024 was issued on the ground that the petitioner did not submit any document did not submit the NOC and the approved plan pursuant to the notice issued on 13/5/2024. He submitted that even prior to initiating any action under section 337(3), the petitioner had approached this court by filing the instant application. He further submitted that as to whether the reply of the petitioner was taken into consideration and what the commissioner, GMC, proposes on the basis of the said reply. Are things within the jurisdiction of the commissioner, GMC. And as such, the instant proceedings is premature. He further submitted that the proceedings so initiated under section 337 by the notice dated 29/10/2024 is a substantive proceedings for which the petitioners are required to file a separate proceedings and not on the basis of any proceedings which were only pertaining to issuance of a notice dated 13/5/2024 seeking certain documents. This court, having heard the learned counsel appearing on behalf of the petitioner, is of the opinion that the proceedings so initiated by the communication notice dated 29/10/2024 is a separate proceedings is a separate and a substantive proceedings which cannot be challenged by way of an interlocutory application. And the same can only be challenged in the manner otherwise provided under law. or by way of filing a separate petition. According to though the submissions made by the learned counsels appearing on behalf of the parties have been duly noted herein above, this court is of the opinion that the petitioner's hearing should be given an opportunity to challenge the said order. Said actions initiated in terms of the notice dated 29/10/2024 by challenging the same in accordance with law. This court have also taken note of the submission of Mr. S. Samaria, the learned counsel appearing on behalf of the petitioner, that the petitioner may be, that the interim order which was passed by this court on 6/11/2024 may be continued for continued for some time so that the petitioner can avail the appropriate remedies can approach the appropriate remedies against the proceedings initiated by notice dated 29/10/2024. The said submission, in the opinion of this court, is reasonable. And accordingly, this court states and directs that the order dated 6/11/2024, passed in IS Civil number 3373/2024, shall continue till 25th of November 2024. The petitioner, in the meantime, can take appropriate steps against the said notice. I stand.
Hello. By the head of order, whereby to close the IMFL of army leader.
Were you?
And for the inlines of
Why? We have started implementing that. We are the stakeholders, madam. We are the stakeholders, madam. They have. This was a test pipe link of Parasi Rambari to Hangabari area. And we have not hard pilot. We raised our objections, madam. And APS pilot.
How many shops are there
Only one shop. There are only the one shop.
in your locality?
My location. In Lemro, there is no shop.
No, not in Lemur.
Agrawari, there is no shop in our.
He's saying that Hengravali doesn't have a.
The in the road, madam, main road. We are there. This madam, there is no shop.
Which name?
This,
From this Kalimundi, how much is the distance? The next.
There is Nopojo pot, madam.
Yeah.
There is no shop.
Oh, nearby. I'm fine there. What are we doing against them? What are we doing against them?
So there we are in the 75 meters.
Huh?
So there's a school and so there's within the 70 years of 75 meters. The same manner. We have raised one objection before that. Our objection was never heard. And purpose of interim order actually it was granted license. Already it was stopped, madam, but no, there was no order communicated to us. That's why we want to make. Reasonable factor.
Yes. Huh? What? Operating, yes. In that area, yes, sir. If they raise any objection, then they have not raised any objection. Why you are not raising it?
Country street has been converted to housing. No, 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 no.
Then why you are not objecting them? You have to see the bona fide of the person, right? Why you are not objecting?
That I'm thinking something like that, because I'm not aware of it. But so far as, well, our case is basically simple, 3 days of patient. Authorities, without considering.
You can raise objection very well, but why you are not raising objection against others if you don't want to visit that area? Why you are not raising objections against others? Don't never raise any objection, unless you see the bona fides also.
I understand, but
Sometimes like this.
because our case is simple, my lord, we have raised objection, my lord, but objection was not heard. That is our case. Our objection was not heard. Before the commissioner, before the deputy commissioner, we have objection. That application is also.
What if they have raised the objection after passing of the fixing order, your lordship? The order was for 7/2/2024. And after that, started running from 8/2/2024. And in the meantime, from 15/2, Arbeli asked to close the shop. Hereafter, on 25/2/2024, they raised the complaint. Even in the same complex. In the same complex, your lordship, from 2021, a country liquor spirit shop has been running. In that case, they have not raised any objection since 2021. And the applicants are not resident within the vicinity of 75. They have residence more than 75 meters.
And except two plates, I think we have categorically stated. Members are deciding on the Yeah, there was a resolution passed by the committee.
Now, how do you permit a liquor shop to come within 10-meter radius of this Jatiya Vidyalaya?
I'm saying that the, 10 meters. One is good. 8 or 3 along. The last. Time. Budget of the. Applicable. Municipal corporation 50 meters, more than 50 meters for the proposed site along. Since this education institution, hospital, public office site is 50 meters away from the proposed site.
In the Mandir,
That is also 50 meters away.
Where? Document
Oh,
the
but
annexure
less
I,
than 75 meters.
the report. Inquiry report.
as per this, it is more than 50 meters.
More than 50 from the proposed site, whether
And as per the rules, how much should be?
as per the rule that group 289 adoption, that some express rule 289, say, no MFL is still off license or retail or system establishment operation within a distance of 50 meters. 28 town communities, area within 100 meters, town panchayat residential body, area within 150 meters.
What is your basis of which you are saying it to be 10 meters? Okay.
Yeah,
Why you are saying it to 10?
this is the radius of 10 meters.
Since it's 10 meters, radius is at the flow flight. You can't go as per a flow flight. This is going to be taken as 50 meters. Beyond 50 meters. This is excessive.
I mean, road distance maybe more than 50, but aerial,
Real means, so they'll get the smell of the liquor.
aerial distance is
What is
very,
this?
the neighborhood pilot, you'll also make kindly see, maybe the vicinity matter. The meaning the vicinity matter.
Infinity won't help you. And why have you stopped? Because of them. You're functioning.
So let's say I'm treated as a parking lot. Fine. Because actually, but you made an application before also. We have made an application before also.
Oh,
No, authority by law.
but you are not, we have made false statements out here, which is contrary. Show me any document to show that that report is wrong.
The report, madam.
You are saying it is 10 meters radius from so and so. What is this radius? Does it say anything about radius? Then the entire basis of your application is wrong.
The radius means, actually radius is what is there.
Understood, but is there rule say about radius?
Who doesn't say about it?
What are you bringing into all these things?
But they have brought it, that's why. The report they have said about radius.
And these persons are within the radius, 75 meters.
This piece, yes, yes. Applicants are within India, they are within the vicinity, by 75, below 70, that we have said it in our application.
Your application, you say many.
The earlier application before the authority matter, that we have said it.
What did you say?
Page 13, lecture 20. In IIM. That is on 25 to 2012. For purpose of review of the other, and also the notice was issued, in terms of the notice, we have made the application before the order. Whether they, because in the notice, they were supposed to file objection. So we have filed objection.
All these persons, where are they residing?
They're residing within the radius of 75 meters.
And why you have not objected?
There was a notice issued in the,
Why you have not objected at the other liquor store?
no, your lordship, they have issued a notice.
I'm asking you, why have you not objected?
That I have to tell you, but what happened, before opening the shop, they had issued a notice. And in purpose of that notice, we filed application before the
An
order.
application has been filed by the applicant seeking impediment to the accompanying petition on the ground that they have objected to the permission granted to the petitioner to set up a IMFL off-license shop within the vicinity of 75 meters of their residence. Mr. R.R. Gogoi, the legal counsel appearing on behalf of the site department, submitted that within the distance that in and around the said locality, there is already a country liquor shop which is operating. And there has been no objections by these applicants or any other person as regards its functioning. Mr. H. Chaudhary, the learned counsel appearing on behalf of the petitioner submits that the permission was granted to the petitioner to shift on 7/2/2024 and thereupon had shifted on 8/2/2024. It is only thereafter on 22/2024, 25/2/2024 that complaints have been filed by these applicants. Which, taking into account the above, this court made specific query upon Mr. P. Kotoki, the learned counsel appearing on behalf of the applicant, as to what steps have been taken in respect to the existing country liquor shop within the vicinity, within their vicinity. He submits that he would take instructions and file an affidavit in that regard. Which lists this matter again on 27/11/2024. Which state, which the affidavit be filed by 25/11/2024. On that way, I may allow you.
Hello, please. Let us try on.
For at least on item 5,
Lordship, the matter pertains to the Assam Agricultural Produce Market at Lordship. This is already actually covered by a division bench order. But what we pray before your Lordship and what we want from your Lordship is the refund. Is the refund amount, Lordship, because they have been illegally collecting. Because our item is coconut oil and refined coconut oil, Lordship. And refined coconut oil and coconut oil is not there in the schedule, Lordship. So they cannot collect. They have been collecting it since 2002, Lordship. So a lot of amount is there, and when we filed this writ petition, there was an observation made that they will keep the account separately. And if we,
What happened to the judgment in other things?
yes, that judgment is relating to item were scheduled, Lordship, and after GST, it was. In this case, Lordship, the item is not a scheduled item at all. It is coconut that is there in the market produce act, Lordship. So division bench judgment is there, Lordship. I'm covered by division bench judgment, Lordship.
Yes, what was the provision that said?
There, the item was mustard seeds. That is there in the schedule, but mustard oil is not there in the schedule, Lordship. The division bench has observed that Lordship, page 6.
Same order,
Yes, your Lordship.
then
It is the same order, but Lordship, in this case, the division bench, as your Lordship has also held that end users, how we will return, that's why there cannot be a refund. But in this case, the whole sale was on MRP basis, Lordship. I have filed an additional affidavit and I have given all the invoices, Lordship. My all sales are on MRP basis, Lordship. Because I bring coconut oil and refined coconut oil from the state of Tamil Nadu, Kerala, and then I give it to the distributors or make retail sale here. Only
But how do you bring it?
by transport cost.
Yes, but how do you bring it? Bulk quantity or how do you?
Yes, we bring it in bulk quality. They
And
Lordship,
then you
handle it.
package it here.
No, packaging also, they pack it and bring in bottles only. Packaging also, it comes ready bottles.
So it is, the package quantity is brought here.
Yeah, packet bottles are brought here and it is sold on MRP basis. Only in 2016, the procedure became different because in 2016, Lordship, we established a factory here, manufacturing unit here to make perfumed oil and hair care products. In those cases, Lordship, we have brought the oil and we have used in manufacturing. That is a different thing. But some of the products, Lordship, we bring it and we directly give it to our distributors or make retail sale. Those invoices I have attached in the additional affidavit. Lordship will kindly take the additional affidavit, Lordship. Page 351 to 370. I have even attached the connected. Lordship, these are some of the receipts. I have not attached all of them. The connected test that has been collected, I have attached that also, along with the receipts, Lordship, from page 351. Lordship.
Where have you brought in?
Page 351 series, Lordship.
Three?
351. Thank
One.
Lordship is the invoices, Lordship, in the third column, Lordship. The first column is the description, then the sales quantity, then MRP, and then the whatever discount they gave, net rate, quantity, and amount, Lordship. No sales is included here. And I have not collected sales while
You
selling.
are Marico.
I am Medico and I
You
have
sell
sold
it to others.
I have sold to person in Fancy Bazaar, Guwahati, Lordship. There are
You
persons in
sold to
Dibrugarh
like-
also all over Assam, Lordship.
Ah. Pune.
I cannot go beyond the MRP, Lordship. So I have not added any cess, Lordship.
And what have you included this 40,000? That is page 352. How does it arrive to 4,69,000?
Lordship, when we give it to the Lordship, when we calculate this, we give some discounts actually to the MRP. On MRP, we cannot give it to the how they will earn from that then. If we are selling it on MRP basis, So if we give, take the MRP price from them, then how they'll give to the customer? They'll not have any benefit. That is the discount.
Understood,
It is
the
less from-
discount is 19,000.
19,000 and then 3,000.
Then less additional discount is 3,300. Net amount is 4,29,000. What is this 40,000?
Lordship, this is the sale, this is the VAT, Lordship.
Huh?
This is the tax, Lordship. VAT, Lordship. It is, the calculation is on the other side, left-hand side above, Lordship will see. Tax amount, taxable amount is there. 11,659, then 28,416. That I have to pay.
So this is not inclusive of taxes. The amount which you are selling it is not inclusive of taxes.
Taxes on the VAT amount.
VAT amount, whatever, this was VAT was there.
This
Huh?
is the calculation only. The net price which I have collected, that I have written, Lordship. Lordship, above the gross billing rate, discount, additional discount, everything is given separately. Lordship.
Why in this case, the other cases, there is no tax? The same goods?
Lordship, there is, in the last column, Lordship will find VAT percentage is there.
Come to 351. Where is the tax?
53, Lordship. Last,
351.
last column, it is there, Lordship. 351, 353, it is in the last column.
Tax description, percentage, taxable
Yes,
amount, tax
Lordship,
amount, nothing mentioned.
in photo state, the marks have gone, Lordship, there is the VAT percentage, last column there is. 353 also it is there, Lordship.
So there you have not mentioned about the taxes.
Lordship, the down calculations are not there. These are invoices which are, some are rough invoices, some are proper invoices like that. Lordship, total calculation is not shown there. I have to inquire why they have not, we have, they
Now
have
they have
calculated
taken the
it.
money in respect to these goods, how do we know?
That-
That it is in respect to these goods, they have taken the money?
Lordship, I have certificates from the dealers also. That also I have attached, Lordship.
Huh?
That no cess has been taken from them.
Okay. The cess has been taken or not, that is, these are questions which has to be looked into, that is another thing. But where is that they have charged you on these items? Yes.
Lordship, it is there, Lordship.
Where?
Lordship, may kindly come to page 361, Lordship.
Mhm.
361, Lordship. 361, 360. I have attached the Form K also. That says has been collected.
In the year 2012. You want it, the year 2012.
Coconut oil, what is this? What is mentioned coconut oil?
361. Date is also 22/9/2012.
Coconut oil, PP and plus home. Wait, hello. Whether cess is leviable is not. Amount of cess.
1%. Again, in 363, Lordship will find against the invoice Actually, it is old records, lordship, each and every invoice we could not attach to the. Again, 363 is the cess collected from.
Yes, how much amount did you collect?
Almost 5 CR, 5,
Hmm?
not 5, till 2020, till the check gets were removed, lordship, till the check gets were removed after GST. Till then they have collected. From 2003 till 20.
But how do you correlate this collection of this coconut oil on coconut oil with these things which you have brought in? With your invoices, how do you correlate? You must have brought in from somebody.
Yeah.
Where are those?
There also it's my manufacturing unit.
So you are getting from yourself.
I'm getting myself. I did a stock transfer, then I give it to the distributors, I give it to the retailers. And they collect cess from me. From whom I will collect? I cannot collect cess.
So it's a case of stock transfer.
I take it from Tamil Nadu and all these papers I can submit if they want the department wants in detail. I can submit them all the papers, each and every invoice, because I could not correlate and attach all invoices. Lordship, there are will be thousands of invoices and Form K that I can give it to them. They can check it, Lordship.
Regarding stock transfer, they have not submitted any document. As management says that there is a stock transfer, but they have not submitted any document before the authority. Any stock.
There was no question of they will get a grant refund and I'll have to go. They have always been collecting. Lordship may kindly come to page 381, Lordship. 38 from 380, Lordship. 380. 380, 381, Lordship. These sort of certificates are also
So
available.
you started manufacturing unit in the year 2016-17.
60.
Thereafter, how is it being taken from you?
Lordship,
16-17, if it is taken, how is it being taken from you?
Lordship, from 16, that will be consumed in the production cost. I have to be to the before. Lordship, that will be taken in account into the cost of production. But before that part, that was
So you are saying about prior to 16-17.
no, but in 16 also there is a division, Lordship. That's why I have to submit papers to the department, because 16 there will be some part goes to the distribution and retail still now.
Are you still going into the question of packaging here? No.
No,
You're
that is
manufacturing.
They
You're
become
manufacturing.
hair products.
So you must be getting some coconut from
Yes.
outside.
We give it to the factory, which we want for the hair care products, and some we give it to, still now we do with the distribution and retail. But before 16, till the establishment of the factory, it was all distribution and retail. That I have made
So we are to only take into consideration prior to 16-17.
prior to 16, 17. Total
After 16-17 does not arrive.
after 16, 17, it has to be bifurcated, Lordship, whatever.
So first of all, your liquidation is of 16-17 months. How do we take care of after 17 till 20?
Lordship, actually what happened, Lordship, they were collecting this MRP, we were bringing the product, we were selling, we didn't go into the matter so much. Lordship, I have made specific statements in my restriction in paragraph
Now, did
16.
you ask for refunds from them?
Yes, your Lordship. After that, when we realized, Lordship, I'll tell what happened. Lordship, before filing this writ petition in 2016, when we took up the work of establishing a factory, then we realized that this cess has been collected illegally from us. Because that time we were taking all the vigilance thing, we were trying to see what tax will be leviable on us and how much we
So
will
you
get.
were running at a loss.
Yes, we didn't know this cess was being collected illegally from them by at the entry gate. So when we did this vigilance, we wrote letters to them. In 16, there are letters in the writ petition. We have wrote to the department that you are collecting otherwise, so please don't collect from us and this is not applicable on us. Then they did not they did not agree to it, so we filed the writ petition. In writ petition, Lordship, the Honorable Court gave us a stay. After that also, they asked us to obtain license in under this act. So we again came before this court by filing of this stay. Then the court said you did not take a registration till the matter is decided. We got a stay on that and that's why we did not have to obtain a license 2016.
But they collected.
But they collected.
But there was no stay on the collection.
There was a stay on the collection. There is Arup Goswami's no stay on the collection. First it was stay on the collection. Then Justice A.K. Goswami's order was there. There you keep an account. Okay, fine, you collect, you keep an account and you refund them if they win in the case, if the case is decided in their favor. Lordship,
That's collected from the petitioner on account of mustard oil. To be carefully accounted for by an India, even the verdict of the court goes in favor, the board would be in a position to refund the collected sales. So that is the order of Justice Roy,
yes.
Rishikesh Roy. Then
Then Rishikesh was another order in 11/9/2017 order, Lordship. This was part
12, there is another order.
another order, 11/9/2017. That is the IA we filed when they were forcing us to take a license under this act.
Notice was issued on 3/3/2017. Oh, there is another order, I mean, this is a different case.
That's
This
a
is
missed case.
Tinsukia trading. That is Tinsukia trading. That was followed out here in 3/3/2017.
That the order,
Extension will be on return for some reason or other, the litigation cannot be decided. We are to review the fair for to get guarantee. So that was there and then question of bank guarantee came. Thereafter, there is no order.
11/9/2017.
So if there is a stock transfer, then there is no liability of payment. Well, just for example, a stock transfer is made in respect to a scheduled goods, then what happens?
We are totally different case law. We are on the, that is not a schedule. Because the dividend and judgment is from master seats. Because of master seats, they were trying to take cess on master oil. Division bench held that no, not on master oil. Master seeds is there in the act, not master oil. Similarly, from in the schedule there is coconut. It's a oil seed. Coconut is there. There is no coconut oil or refined coconut oil in the schedule. Now they are trying to take cess on that law.
No, the division bench then also, in spite of that order initially, that you maintain accounts, did not direct refunds.
So the chief master oil, that is.
Yes, there was no direction for refunds.
There was no direction for refund because they could not correlate, which was Lordship's order also. in the last case series which Lordship gave an order, passed an order, in that we could not correlate how we will pass on the cess. Suppose they refund the cess to us, how we will pay it back to our end users from whom we have collected. That we could not correlate. That's why it was not paid to us. Refund was not given to us. Undue enrichment. In this case, Lordship, this we have not passed on to any. Because in stock transfer, when I bring the things and I sell it on MRP, I cannot increase my MRP any. My MRP is fixed.
But the MRP, within the MRP, that must have been included.
No, Lordship, how? MRP was settled there only, outside where the
But
manufacturer.
you have only settled.
But that was settled outside only,
But they are,
We cannot increase and sell them in the MRP, Lordship.
Huh?
MRP, we cannot increase the MRP and sell here, Lordship. MRP is
you are the owner. You are the manufacturer.
fixed. Lordship, MRP.
You are doing it.
Lordship, MRP, we cannot increase, Lordship. That will be fixed, Lordship. I cannot
Lordship,
go beyond
taking
the
into
MRP.
consideration.
MRP was fixed, taking into account all other things, Lordship, not the cess. And they cannot, Lordship, the government also, they cannot collect something which is not allowed.
And how did Tinsukia Trading bring in? That aspect is not clear. Tinsukia Trading brought in also.
Yes.
Was it a stock transfer? No. Tinsukia Trading was not stock transfer.
Doctor. This aspect was not there in Tinsukia Trading, Lordship. This is peculiar in this case only, Lordship.
No, I think we will hear this matter further. But this is relevant to look into whether. Why you improve the judgments of the citizen? But nothing is done. Anyway, this matter again on 26th November. Huh?
Lordship, Lordship, not 26,
Part of the occasion, huh?
26 with marriage and
28.
27,
You say 26 to 27 and 20.
29, Lordship,
29th is Sunday, Saturday, Friday. We'll take it up at 5 o'clock.
Lordship. Second December.
Okay, have you seen the list? There is one matter. Taking up as the last item of it. So we'll have it on 29th as the last item of the day at 5 o'clock. Start the hearing till 6:30. No, absolutely no. I will fix it as per my convenience. This the matter again on 26th of November 2024.
29. Lordship. 29.
20
Lordship.
taking into account that the heard the many parties, taking into account that various questions of law have been raised. This court admits the rule be issued, taking into account that the pleadings have been no additional copies of the petition be served. Matter of
Item 6.
and appeals on behalf of that the petitioner was presented at the earlier occasion also. This seems that the petitioner have lost interest. Bunch of petitions have dismissed from them.
Item 10.
May please, the last occasion, I have received some instructions on this. Regarding the correction of Patna.
Yes.
My lane is kind of wrongly. As a government.
Who is in possession?
Hello, it is page 24 is, the circle officer and Mandal were verified, my lord.
Even then, my lord, that defense officer,
Why you are making the defense state officer first?
my lord, that land was record for the, my lord, the airport.
Defense forces, my lord.
Is that?
So that's why, my
Get
lord,
anywhere, but if the land is acquired also, but possession have not been taken, what it means?
documents, my lord, that document kindly prove that annex, lordship letter issued by the defense officer, lordship by the 12/11/2024. The last, and my lord, that I have given the instruction.
Whether any land compensation was paid to the position of the government. And pursuant to the order passed by this court on 4/11/2024, the additional district commissioner Kamrul Gurgaon had submitted an instruction seeking some more time for carrying out the joint survey in the matter and also for the purpose of tracing out the relevant documents, was taking into account the above. In 6th of January 2025, full stop. In the meantime, the district administration along with EO Guwahati and Airport Borja shall be necessary joint verification and carry and thereupon submit and thereupon file an affidavit as regards its stamp. The instructions so placed before this court are kept in record.
Sandeep Rivle.
11 and 12.
Any negotiation?
My lord, we have ready for eligible settlement, my lord. My lord, yes, refer to the mediation, my lord.
Huh?
Refer to the mediation, my lord.
What?
Because both the parties are ready, but they have not talked in between. I don't know any information from them.
The matter about?
I thought there is a allegation of illegal construction. I thought that allegation has been raised by the respondent number 6, my lord,
Ah.
against the petition. And on the basis of that, my lord, an order has been passed which is under challenge in this petition.
But why you have, an order has been passed? If an order is being passed, how can there be a mutual understanding? He may say tomorrow that, okay, I have nothing to say.
My lord,
How
that
do you
aspect
set
is-
aside an order?
That aspect is there, my lord.
Then this court by an order dated 4/10/2024 fixed the matter today in view of submissions being made that certain mutual negotiations were going on. However, the same negotiations as per the learned counsels appearing on behalf of the parties have not yet fructified. Be that as it may, this court has inquired as to what is the subject matter of the instant petition, and be that as it may, this court, upon perusal of the materials on the board, finds that there is an order being passed by a statutory authority on the basis of a complaint being made by the private respondent.
I am the petitioner number, I am the petitioner
In
in WBC 649.
item number two, okay, but here we are concerned with Jogeshwar Bora. a private respondent in WPC number 8303 of 2018 with the pursuant in the 291 of 2015. Taking into account that that order has been passed by way of a statutory authority, the said order cannot be nullified on the basis of such a mutual agreement, mutual understanding between private parties. Accordingly, this matter again, 8th of January 2025.
Dean,
Which state is for to take up the further proceed. Take up the matter for. Yes, Mr. Roy.
Here, the petitioners who were the tenants, I was the erstwhile proprietor of of a religious institution. They have claimed settlement under section 15 of the Assam State Acquisition of Land belonging to the religious and charitable institution. Well, the DC has filed an affidavit. The DC admits that we were the erstwhile tenants of the erstwhile proprietor. Also admits, my lord, that after the 71 Act came into being, our names are recorded in the Satyan. But when the District Revenue Authority sent a proposal for construction of a government model college in the land which attracts our land, we approached this honorable court. Honorable court states the impugn order, and the proposal was also not approved by the government till today. Now, our prayer is, my lord, that the land, because since there is no formal order of settlement, our prayer is for settlement of the land because under section 15, we being the tenant, my lord, the riots of the erstwhile proprietor, we are entitled.
You have applied.
We have applied.
Then what
But the government said, my lord, we have applied, our applications are also here, next at page 8.
Understood, we have applied, then what happened?
The government is not doing that till today, but the fact remains that
But this in letter dated 26/10/2018 has been made redundant.
it's a state by your lordship, so this is not still approved by the government because of the stay order passed. So they may do it, but that's why not. Since it attracts our land, we are landholders, and occupancy tenant under the 71 Act. So that is admitted because our land has been recorded in the Satyan.
Let's find out affidavit. The stamp in the affidavit is there. First of all, my lord, these people are not in possession. Who? These people.
Not in both.
That is. Secondly, the original land was in the name of Mukunda Baptist Mission. It's a religious institution. And in terms of proviso to section 15 of the 59 Act, they have to be of the same religion. And there is no whisper in the petition that they belong to the same religion. So their status is riot. Boom. These are the.
It's not so. It must be the section 15 proviso says that when the land is settled to us, we cannot transfer it to a person of different religion. That is the only provision. It's not that it cannot be settled. The proviso only says we cannot transfer it to any other person. That's the only. That the lordship on the last.
Can it be settled to you?
My lord,
So what provision?
section 15, lord. Lordship, kindly have a look at that.
15.
Section 15 of the Assam State Acquisition of Section 15. It says,
Why are you coming out here into this question of acquisition and settlement of acquired land with persons of occupation? Subject to the limitations prescribed under section 4. That a land acquired under the factory occupation of a right, the date of application shall be certificate to the document to require the status of a occupancy pending when the land shall be settled.
My lord, this is the dispute list permission of law. This is a bit lordship will see.
Provided further that notwithstanding anything contained in the Assam, the right of transfer of such holding
Shall
shall extend only to persons
Ah.
belonging to the same religion as the institutions in which the ownership of the land was vested before the date of the year. So it has to be settled.
No, my lord, it says, the lordship will tell the earlier provision that is given, I think your lordship, it was earlier, specifically said, he cannot transfer. The lordship, which is there, the earlier provision, I have got a copy of the earlier one. Because since the Senate Tenancy Act and Godfather Tenancy Act has been marched to the Act.
But Mr. Law, you have already put it section 15 out there. in fact.
Yes, my lord, section 15 says, this will be clear if your lordship sees the earlier provision. This will be clear. If it is there, but in the lordship.
And it shall, upon such settlement, be absolved from obligation if any of rendering service or reconnaissance. And if he has not acquired the status of occupancy tenant, then the land shall be of satisfaction other than as defined.
It says he cannot transfer.
Provided, however, that notwithstanding anything contained in the type of transfer of such would be can extend only persons belonging to the.
Because land and devolution
They are
says,
getting the agreement.
land and separation says, provisional says that I can transfer it to anybody once it is settled. Now here said if it is settled, because my right is given in section 15A. It says provided that such the right of transfer of such holding shall not be, because I cannot transfer to any person other than the person of the religion. If it is Hindu, I cannot transfer Hindu. Because it is a Christian rule, I cannot transfer to a non-Christian. That is the provision. And if your lordship sees the other earlier provision,
So the question, therefore, the issue involved of here is as to whether upon an interpretation to the proviso to section 16,
lordship,
there can be a transfer of the land. Can there be a settlement of the land to a person not belonging to the same religion
my
as the institution in which the ownership of the land was vested before the. It's the issue.
That's it. My interpretation is this, because this is how I understand. And
The issue involved in the institution pertains to whether I go to section 15A, the Assam State Restriction of Religious or Charitable Institute, Public Nature Act. Prohibit any settlement to an occupancy tenant as a landholder or if the person had not acquired the status of any occupancy tenant, then as settlement holder. Of a different religion. that of the institution in which the ownership of the land was vested before the date of the notification under section Act of 19. Taking into account that the state aspect to an interpretation to the provision and as a score fixes this matter for admission hearing 17th of December 2024.
Fourteen,
Kindly this meeting is taken at 2 o'clock, Lordship. I am on behalf of Place Foundation.
So as per you, the false documents have been lost.
Malam. The Lordship directed last occasion, Malam, on 3 Malam. Then instead regarding status of the status report. Malam.
Status of the investigation in respect to
Fine.
Bilasipara case.
Malam. As per my WhatsApp message received from the additional SP Jubri Malam, charge sheet number 10 of 10 dated 31/20. Has been already, Malam, charge sheet has already been submitted, Malam. And that is the information as per the last one.
The charge sheet.
But the contents of charge sheet are not received only, Malam, regarding information that
The case submits the question to the order dated. And intimated her that a charge sheet has been already filed in Bilasipara PS case number 169 of the
30th of January 2020.
January.
301.
Yeah. Taking into account matter again on 29th of November. And the actually the charge sheet which have been filed. 6. Your document.
15 to 20.
And the PGCL, what is your feeling?
That has my lord, submitted a FTP in opposition, my lord.
Like 50,000 was done as per the earlier. Now it is 4 lakhs. But the fact being that that amount is just being paid as an urgent necessity. But the remaining amount, you can still file a suit.
This court has power.
Huh?
This court has also power, my lord.
This court has to,
Power, my lord.
for what?
Full compensation because, my lord,
And this court is not going to do that.
as per judgment of the Raman, my lord, Supreme Court, Honorable Supreme Court, my lord.
Huh?
Someone in a case which was reported in 2014, 15 SSC, man.
It's long time. It's now they have already had a. Can you show me the earlier, did you claim anything prior to that?
Yes, there was an OM prior to that also.
These are the two.
Disorder.
Yes, initially in 2013.
Board of directors of the IEC, right? So this is done under which act? 2013.
Acts and the 2003 Act does not mandate that competition activity, but in new rules, your lordship, there is an obligation on the distribution licensee to maintain standards of distribution.
Now you have made it 4.
Now we have made it for one failure of the distribution licensee to meet the standards of distribution. This competition was more in the nature of an ex-gratia, regardless of
But
whether
this should not. It should not absolve him. to
it
Get more money.
does not. His private law remedy remains.
We are not going to interfere with him. But giving you the liberty to file a suit seeking additional compensation. Because you have to then prove. You have to prove that this was his income. And if this was the income, he would have lived. And as such, he would be entitled, applying that multiplier and all this. You have to prove it in a suit.
But you cannot go to the case of the Supreme Court reported in the. Well, that was the case, my lord, High Court has granted, my lord, 60 lakhs. And thereafter, my lord, appeal, my lord, was, my lord, some modification, then went to the Supreme Court, my lord. My lord, Supreme Court says, my lord, adequate compensation, man, just and fair adequate compensation, man. And under 226, my lord, I have a judgment, my lord, this court has, my lord.
And differential lordship perhaps would be. That in this matter, it was filed paying for compensation. Here they have already accepted the amount of compensation as per the earlier notice. In effect, it's a petition paying for enhancement of compensation.
That's the fair law.
You have to apply this type of law, then
My lord,
tomorrow we should shut down our
Para 16, my lord, Supreme Court.
MSCT courts, civil courts, everything.
My lord, in para 16, my lord, the Supreme Court held that, my lord, multiplier method is not applicable.
Go to Supreme Court. Against my order, go to Supreme Court.
My lord, in para 16, it is held that, my lord, multiplier method is not applicable in this sort of cases.
What is applicable?
My lord, it's a, my lord, just and fair compensation. my lord. So, my lord, this court has, my lord, the power under 226, my lord. I have another judgment, my lord.
Other high court also, my lord, applying.
Going to go into all these things. These are constitutional thoughts. The constitutional
But
thoughts.
in, my lord,
Where is
1990,
the negligence? Let me dismiss your petition right now. Where is the
they
negligence?
have admitted the negligence, my lord. Due to one person negligence, this has happened, my lord.
So?
Yes, my lord.
No, was the negligence such that effect that he had to die?
Yes, my lord. One person informed that, my lord, already live wire.
Huh?
Live wire was, that they have been informed that live wire already had been cut. But thereafter, they went to fishing. And this, my lord,
Who went to fishing?
is petitioner. Petitioners, my lord, some son and my lord,
Who informed? Life wire was cut.
but as per FIR, my lord,
No, who informed?
my lord, in FIR,
No, who informed that the life wire was cut?
one person, his name is my lord, Lordship, they have stated in their affidavit. in
No, forget about the affidavit. I'm asking you, who informed?
Lordship, the lineman.
Huh?
Lineman informed, my lord.
So have you made the lineman a party? Because he has to be cross-examined. Make him a party. You want this court to look into this. You are to also, maybe he have made, if he has made or not, did he inform or not?
My lord,
Actually, he has informed or not?
they have taken my lord action against that lineman, my lord.
They have taken an action, that person, whether did he say that? That has been taken a departmental action. A departmental action from that and to find it to be a constitutional thought, whether APDCL can be made responsible.
My lord, that Lordship may grant sometime, my lord,
No, no, you first make the lineman a party. We'll issue notice, we'll ask him, then whether if he says that no, I did not inform, then it's a different aspect.
Right.
Make him a party.
all the five matters.
Huh?
In all the five matters, yes.
All the 5 matters, you have to make the lineman a party.
Yes, my lord.
Absolutely no. I'm going to dismiss the petition. I'm coming back. 2 o'clock, I'll dismiss it. Go to the division bench, go to the
Any other day, my lord.
today. Same incident.
Yes, ma'am. 6%, my lord. Fiber fisherman, my lord, one student.
Charge sheet file. Charge sheet file.
That's it, my lord. I will use the UV case, my lord. I have connected the postcode report, my lord.
Heard, Mr. Lorenzo, the Linux Council is hearing on the top. It's the KP Pathak, the Linux Standing Council. APDCL appears on behalf of the respondents.
Phone number is 2260.
APD appears on behalf of the APDCL and F appears on behalf of the state of Assam. Instant batch of repetition. Have been filed. Challenging the office memorandum dated 25/9/2017, whereby the APDCL, whereby Assam Power Distribution Company Limited, for short, APDCL, had fixed a uniform rate of rupees 2.50 lakhs as compensation to be payable to the next of the kin of the victim who died due to an electrical accident, irrespective of the age of the victim. The petitioners herein have sought for the petitioners herein who have admittedly accepted the amount of rupees 2,50,000 have sought for enhancement of the said compensation amount. In all case, 50 lakhs, na? To 50 lakhs each against the victims who expired. Next. The facts leading to the filing of the instant petitions are that the that on when did this incident happen? 21/9/2018. It can't be, is it? That on 21/9/2018, six persons expired on account of electrocution or due to electrocution. In view of the fact that the departmental linemen, the linemen of the linemen of appointed by the APDCL authorities had wrongly informed these victims that he had cut the line and asked them to go ahead with the fishing. In that regard, an FIR was filed on 21/9/2018, and a case being Rupohia Hart PS case number 596/18 was registered under section 338/304 of the Indian Penal Code. It is further seen from the materials on report that in terms with the office memorandum dated 25/9/2017, the APDCL authority had paid an amount of rupees 2.50 lakh to each of the petitioners who are the legal representatives of the victims, 6 victims who expired. The claim of the petitioners herein that the loss which have been felt on account of the death of the victim upon the petitioner is far more than the compensation so awarded by the APDCL authorities. It is under such circumstances the office memorandum dated 25/9/2017 has been put to challenge. And further, have sought for appropriate redirection and order for enhancement of the compensation to the tune of rupees 50 lakhs each. Pursuant to the filing of the petition, affidavits have been filed by the APDCL authorities wherein it has been mentioned that the victims were negligent in venturing into the pond for fishing when there was a wire lying or floating over the pond. It was further mentioned that the petitioners in the batch of writ petitions have duly accepted the amount of rupees 2,50,000 without any protest of the complaint. And as such, the petitioners are now stopped from raising any further demand. In addition to that, it has also been mentioned that the office memorandum dated 25/9/2017 was issued by taking into consideration the various factors in addition to that, it has been mentioned that there is no materials which can suggest that the petitioners herein would be entitled to higher compensation, inasmuch as there is nothing to show as regards the professional income of the victims on the basis of which any compensation can be determined. In the backdrop of the above, let this court now take into consideration the submissions made by the learned counsel appearing on behalf of the parties. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the amount of rupees 2,50,000 which have been awarded to the petitioners on account of the death of the victims, 2,50,000 each to the petitioners on account of the death of the victims, was totally disproportionate to the loss sustained by the petitioners. He further submitted that there was gross negligence on the part of the respondent authorities, inasmuch as had the lineman not informed the victims that the line was not cut, and that the had not informed that the line was cut and they could go for fishing, they would not have ventured to the ponds. He therefore submitted that this is a case where a constitutional tort have been committed, and as such, the petitioners are entitled to a higher compensation as has been claimed in the writ petition. In that regard, the learned counsel referred to the judgments of the Supreme Court in the case of Raman versus Uttar Haryana Bijli Vitran Nigam Limited, reported in 2014-15 SCC 1, as well as Nilabati Behra versus State of Orissa and others, reported in 1993 2 SCC 746, wherein in exercise of powers under Article 2 to 6 of the Constitution, the courts have granted compensation on account of constitutional torts. Par contra, Mr. K.P. Pathak, the learned standing counsel appearing on behalf of the appealing cell, submitted that the office memorandum dated 25/9/2017 was made as an ex gratia to be paid to those victims who expired, to the next of the kin of those victims who expired due to an electrical accident, irrespective of the age of the victim. He submitted that the petitioners herein have duly accepted the amount of rupees 2,50,000 without any protest, and as such are stopped now to file the instant to claim any further amount by filing of the writ petition. Anything more?
They have not closed any material substantial claim.
In addition to that, the learned standing counsel further submitted that the claim made for enhancement of the compensation has to be based upon materials and evidence which have to be led. Because nothing to that effect have been brought before the court, which would suggest that the petitioner herein would be entitled to any further compensation other than what have been already paid on the basis of the office memorandum dated 25/9/2017. He further submitted as to whether there was any fault on the part of the APDCL are questions of facts which cannot be adjudicated in the proceedings, and to determine as to whether there has been a case of a constitutional tort. To replying to the judgments, place reliance by the learned counsel for the petitioner, Mr. K.P. Pathak, submitted that the said judgments could not be applied in the facts of the instant case. Firstly, for the reason that those judgments were not, had no, those judgments were in respect of those judgments do not deal with cases where the next of the kin of the victims have already received compensation. In order, in addition to that, the learned counsel, standing counsel further submitted that there is no materials on record which would show that there has been any negligence on the part of the APDCL authorities, which was otherwise the case in the judgment so referred to by the learned counsel appearing on behalf of the petitioner. Isn't that? Upon hearing the learned counsel, this court put a specific query upon Mr. K.P. Pathak, the learned standing counsel, appearing on behalf of the standing counsel of the APDCL, as to whether the, in view of the office memorandum dated 25/9/2017, the petitioners are precluded from claiming further compensation if they are otherwise entitled as per law. The learned counsel, standing counsel submitted that the office memorandum dated 25/9/2017 is a form of an immediate compensation so paid to redress the next of the kin of the victim. And as such, the victim, the next of the kin of the victims are not precluded from claiming further compensation if it is otherwise permissible under law. Full stop. The learned counsel further referred to that pursuant to this office memorandum dated 25/9/2017, the Assam Electricity Regulatory Commission have also framed a compensation. What is the name?
Assam Electricity Regulatory Commission, compensation to victims of electrical accident regulation 2009.
And I'm too left. Slowly.
Assam Electricity Regulatory Commission, within brackets, compensation to victims of electrical accidents regulation 2009.
And submits that in that regulation also, as per section 9, na?
Section is under 5, regulation 5.
9999.
The liability is under 5, that is
9. Come to 9.
other rights in
Yeah. That as per regulation 9, it is categorically mentioned that the compensation which is being paid under under regulation 5 shall not preclude the persons, the victims, the next of the kin to claim further damages if they are otherwise entitled as per law. In the backdrop of the above submissions, in the backdrop of the above, this court have duly considered this court having perused the materials on record and having heard the learned counsels of the petition parties, have given an anxious consideration to the subject matter involved, the subject matter of the disputes involved in the instant proceedings. The office memorandum dated 25/9/2017, as stated by the learned standing counsel of the APDC, is only an ex gratia payment when a victim, the payment to be made to the next of the kin of the victim who died due to an electrical accident. And in that regard, a compensation of rupees 2,50,000 is to be paid irrespective of the age of the victim. The same being an ex gratia payment cannot preclude the victims of the next of the kin of the victims who died in an electrical accident to claim further compensation. If they claim further compensation, subject to the law, subject to be permissible, subject to materials being placed for enhancement of the compensation, materials placed for subject to evidence led that the victims of the next of the kin of the victims are entitled to a much higher compensation. Taking into account that the office memorandum dated 25/9/2017 only relates to an ex gratia payment, and the same does not preclude the victims, the next of the kin of the victims, to claim further compensation. The question of setting aside the office memorandum dated 25/9/2017 does not arise. The next question which arises before this court is as to whether the petitioners in the instant proceedings can claim a compensation as sought for in the petition. For the grant of any higher compensation, it is a compensation. It is the opinion of this court that the petitioners have to prove by way of evidence that there has been a negligence on the part of the APDCL authorities. In addition to that, the petitioner, the next of the kin of the victims, have also to prove by way of evidence that they are entitled, that the compensation that the compensation so awarded on the basis of the office memorandum dated 25/9/2017 is not sufficient, and therefore they are entitled to higher compensation. However, it is very pertinent to mention that the facts that the pertinent to mention that to adjudge the question of negligence as well as the question of the inadequacy of the compensation cannot be decided in the instant proceedings under Article 2 to 6 of the Constitution, as it would require evidence to be led, as it required evidence to be led insofar as the negligence on the part of the epidician, as well as also as regards the inadequacy of the compensation. The materials before this court, as have been placed by the petitioners, are insufficient to adjudge such aspects. Accordingly, it is the opinion of this court that in the instant case, the question of granting any compensation to the petitioners in the instant proceedings does not arise. However, it is this court is of the opinion that the petitioners herein would be entitled to claim compensation by filing suits before the competent court of civil jurisdiction, claiming compensation, claiming a higher compensation. This court, accordingly, the instant batch of petitions are disposed of with the following observations and directions. Number one, the office memorandum dated 25/9/2017 do not call for any interference. Number two, the petitioners herein cannot be granted a higher compensation, any compensation, in as much as the question of negligence as well as inadequacy of compensation can only be decided by way of proceedings wherein evidence can be led. Number three, the petitioners herein are given the liberty to approach the appropriate civil court claiming compensation from the epidicial authorities. Four, the observations made herein above shall not affect the rights of the petitioners to claim compensation from the epidicial authorities. Five, the period from the date of filing of the instant writ petitions, that is with effect from 17/6/2019 till date, be excluded while computing the period of limitation.
Item 21.
Yes, what is this?
Kindly peruse the order date 29/11/2023, Lordship.
29.
11/2023.
2112.
Yes, Lordship.
Oh, that matter. Which matter is this?
Lordship, after date,
Mr. Nayak, which one is this?
that unauthorized construction of,
Of?
of a warehouse.
Yeah. What happened now?
Lordship, notice was issued on 5/1/2024. Lordship.
Hmm.
Subsequent there to Lordship.
Construction of the street.
Petitioner urging the respondent replied on 1/2024. Lordship, can we take the instruction, Lordship, that I received on 25/10?
Okay. Dealing with the JNK would be free. The costing of the doing the matter. Yes.
The first one is the notice, Lordship, 5/1/2024.
You are Mr.
Petition number 2, Lordship. Department.
Deepak.
Yes, Lordship.
Now you are complaining of a construction of a godown.
Yes, Lordship.
without permission. Go down on the wall.
Lordship, I have filed two complaint petition before the JMD authority. One is for construction of godown, unauthorized construction. And one is for Lordship, covering my entire plot of bike, constructing boundary wall, Lordship.
Who made the wall?
Asuna number 4, Lordship.
Your boundary has been covered.
Yes, Lordship.
You
It's
can't go out.
boundary wall. Now,
How do you go out?
Lordship, when when I filed this case, Lordship, at the relevant point of time, my entire plot was covered by boundary wall. Now they have constructed a building over here, Lordship, in Dock number 270 and 278. And in Dock number 4,
Whose land is that?
Lordship,
Whose land is that?
that is our land, Lordship.
So they have constructed.
Yes,
They
Lordship.
are in possession of the land.
Yes, Lordship.
You have filed a suit.
Yes, Lordship.
Suit for what?
A declaration of right curtail interest and recovery of first position in the lower court, Lordship.
Then
Subsequently, I have filed a complaint before the JMD authority.
Uh.
Thereafter, they have issued a notice to the respondent number 4, whether he had taken any NOC from the concerned authority or not, Lordship. Thereafter, they have issued a notice under section 87 and 88, Lordship, for demolishing the godown as well as the boundary wall of the particular separate plot of land. But the JMD authority did not take any action for, that's why I have filed this petition, Lordship.
but can't you get a decree for, are you not asking for decree for eviction? For recovery of cost and possession and by demolishing the structures constructed thereupon? That must be your prayer in your recovery. If that is there, a suit had been already there, then why should we at all take into account that? Yes, they have not done, that's a different thing. We take note of that. Whether they have done or not, that is otherwise. But would it be proper for this court to again take it up with respect to the matter?
Also, in the civil suit, JMD is not a party in this. JMD is not a party in that.
That's not true. GMDA is not a party. Now you are taking recourse to the GMDA for the purpose of demolition. Isn't it?
Yes, Lord.
Now, you are questioning the inaction on the part of the GMDA. Or in other words, you demolish the particular, get it demolished to the statutory authority, which prayer you are already having in the suit. Isn't it?
But
Isn't that your prayer in the suit?
till today, the respondent number 4 did not file their written objection to the injunction petition filed by our side, Lordship. Till today. For
Have
which,
you got an injunction?
Lordship,
Have you got an injunction?
no, Lordship, the opposite party did not file their written objection till today, Lordship.
So
The
why you are not,
Honorable trial court already.
then why you are not
was
filing
upon
an
them
appeal
also.
against them? Why you are not filing an IA out there? Instead of doing the case by yourself, why don't you ask somebody else of your colleagues who does civil matters to do it? Ask Mr. S.K. Bose, he will help you out. Take help of a civil lawyer. Don't try to do these matters. Therefore, my order was very specific. Asking Mr. Nayak that irrespective of all these things, is the JMDA going to shut its eyes if there is an infraction to the provisions of 87 and 80? That was therefore my line of inquiry. That is why I have asked them to look into as to whether they are going to take any action, irrespective of what we do. They may say that if we don't receive a complaint, we may not. They may say that it is our discretion, I may not. I'm happy my rules are being violated, I don't mind. They may say. But the fact is that you have already asked for same relief in the suit. You may again entitled to again initiate a petition. You can very well file an IA there. Why didn't you make the GMD a party? Tomorrow GMD is not there. Tomorrow you may ask he is having a Godown license and make again the shops and establishment the department apart. And find another issue. Taking advantage of the fact that you have the legal acumen which the respondents may not have. At the end of the day, this is what you are asking the suit, isn't it? Yes, Mr. Nayak. What are you doing?
When the matter was listed on 21/12/2023,
We take your seat. If you say more, be respectful. Let us hear Mr. Nayak.
Yes, lordship notice was dated 5/1/2024. Next page, lordship must have seen that notice. Their reply was on 1st of February 2024. In their reply, they mentioned about one sale agreement dated 23/9/2023 in respect of the same plot of land. And also about an LOC dated 21/6/2012, issued by the local government for construction of the, I mean,
2012.
yes,
At that time, whether that area was within the
not,
GMB.
not on that. That is there in the instruction. Came at that point of time, it was not. Lordship, in that statement, they have also mentioned about one civil suit that is pending.
But have you got the permission from the GMB? This one, to Premoda Burman and Bharti Burman?
Yes, the earlier one.
With reference to your application dated in month seeking no objection for construction of an Asanta for the purpose of without. You hereby accord NOC to carry out the works of construction of the and an estimate by not going forward.
After thereafter, we issued one letter to the Gram Panchayat office on 8/4/2024. And their reply was 22/4/2024. They accepted that as certain was issued.
Lordship, kindly peruse my additional affidavit filed by, as I mentioned, kindly peruse page number, Lordship, 136.
Lastly, Lordship, on 28/7/2024, a letter was issued to the complainant of the account. Two clarifications were sought for.
No, but you have not got till now the Gaon Panchayat thing. The reply from the Gaon Panchayat.
Yes, they replied, Lordship, on 22/4/2024. I mean, just next to the yellow flag.
With reference to the reply, which is permission to the NOC near. Then, and at that point of time, it was not within the GMD.
Oh, Lordship.
So under such the GMD had no business.
The local government said. And
Lordship,
on
kindly
28,
peruse the page number 136, Lordship,
What is that?
in the additional affidavit,
136.
36, Lordship.
Uh,
Lordship,
Mm.
what happened in this case, when the matter was listed on 21/12/2023?
No, Mr. Bowman, the fact that I'm not concerned with this. You have an interstate dispute between you and them. You are trying to rope in them. They come up and say, I have only asked Mr. Nayak at that point of time, is the GMDA going to shut its eyes if there is an infraction to 88 and 87 and 80? He said that we are not in a position to do anything because at that point of time it was outside the GMDA and the Azra Gaon Panchayat had given this particular thing. They had given a permission. So it cannot be said now that it is the GMDA has not acted. So we'll prove this.
Lordship,
What
kindly,
asked
Lordship,
letter-
kindly peruse the page number
I'm not
137,
going to
Lordship.
look into all these things. First of
Lordship,
all, you have
Lordship
a-
already issued
you
to
know
me,
what to do.
Lordship issued me that there is no permission was granted. In the,
Permission was granted.
no, Lordship, in the reply dated 22/1/2024, Lordship. Kindly peruse 120
22/4/2024.
21/2024.
The Secretary GMDA, this is the letter which has been written. With reference to the letter number so and so, I am furnishing here with the NOC copy and the approved drawing for construction of the godown issued by the then President and Secretary of the office in the name of Bharti Burman and so and so.
Lordship,
This
kindly
is the
page,
permission.
there is a page number 137, Lordship.
Where's the permission?
137, Lordship.
It is enclosed along with the reply filed by the petitioner. I mean the respondent.
Lordship, kindly page the 137 page.
Then one reply dated 1/2/2024 is there, Lordship. The very big-
But today somebody filed an affidavit.
One additional they have filed. There
What
they
is
have
this? No objection. I reserve the right to cancel the NOC. So. Therefore punishing the. No, nothing. going on.
Lordship, kindly page, there is a page.
We dispose it of imposing a exemplary cost
The
on this.
president of Azhar Gaon Panchayat.
You have taken the time of this court unnecessarily.
Lordship, kindly page the page number
We
137.
dismiss your petition with cost. The cost should be how much?
Lordship, kindly page the page number.
Address of that. How much cost?
Lordship, president of Azhar Gaon Panchayat.
How
already-
much fees you have taken from your client? You, yes. How much fee? Tell him in his ear. That would be the cost.
Lordship, kindly page the page number 137, Lordship.
We will submit the bill. to
Lordship,
you.
president of Azhar
Absolutely
Gaon.
no. This is an encourageous litigation. You cannot come up with like this. You file a suit. After that, GMDA. Now GMDA has not taken an action. Now GMDA categorically says that we are not in a position to take
Lordship,
because at
the
that point
president
of time it was not. I am not going to look into the question of whether the permission was rightly given or wrongly given. That was the permission is there. Then challenge the permission. I will challenge the 21/4, the 21/6,
Lordship, no notice was issued to me, Lordship.
Absolutely no, nothing doing.
Lordship, kindly page the.
You know what to do.
Lordship, kindly page the 137 page number, Lordship.
Of what?
Lordship, the president of Azhar Gaon Panchayat already.
Why you are not getting an injunction before the trial court?
37, Lordship, page number.
Yes.
Lordship. On page number 136, the application sought by me, 27/12/2023, that whether any permission granted in the name of my mother, namely Bharati Burman, and my elder mother, Premoda Burman, Lordship. In this regard, the president had given me reply on 2/1/2024, page number 137, Lordship, that there is no any record found for issuing warehouse NOC in the name of Srimati Bharati Burman and Premoda Burman within the period from 2011 to till now. Lordship.
Is the Azara Gaon Panchayat there?
Yes, Lordship.
Is the party? Who appears for the Azara Gaon Panchayat?
The party.
Huh?
The party.
Make the Azara Gaon Panchayat a party. We take action. Pursuant to the, and Mr. Naik, there is a categorical direction to you to file an affidavit, bring it on record, this thing by Brad.
Lordship, can they see the last letter, Lordship, 28/7/2024? Here the claimant, complainant was asked for status of the, prevent suit, Lordship. And if any injunction order is there, that clarification is there.
He doesn't have an injunction. He doesn't have an injunction.
For delay,
That is immaterial, but he doesn't have an injunction. But that is not the question. The problem arises is why this Azara Gaon Panchayat has given two different types of here. Do one thing, you file your affidavit, bring it on record only, don't name much. This document and say along with the enclosure, the enclosure to this document. Because don't say that because of they bring in. What they have given, you bring in. And then thereafter, you say that it didn't fall, it fell only later on, and as such, there was not necessary for us. Just for that, we close the GMDA chapter. Mr. P. Naik, the learned standing counsel of the GMDA, appears and places before this court a set of instructions. So, amongst the instructions, it is also apparent that communication was issued by the secretary, 33 number Azara Gaon Panchayat, wherein it was mentioned that in the year 2012, the permission was mentioned that on 21/6/2012, permission was duly granted to the respondent number. Which Pramila Burman and Bharti Burman, who are the respondents?
Lordship, Bharti Burman is the petition
Huh?
number one.
They are a petitioner.
Lordship, Bharti Burman is the petitioner number one. After Monota is nowhere reflected in this case. Your Honor.
NOC was issued in their. They obtained the NOC.
And you say there is no NOC.
Yes, Lordship. There was no NOC issued against my mother and my elder mother. Lordship.
Was issued in favor of the petitioner number. Bharti Burman is who?
Petition number one, Lordship.
The petitioner number one. As well as one Pramila Burman. Good stuff. What type of document is this? Agreement for sale?
Lordship, what happened actually, Your Honor? I know the respondent number for since the year 2009, Lordship. And he had taken power of attorney. I have submitted in my reply, Lordship, in page number 103 to 123. He had taken two power of attorney on different court of lands. And for taking some NOC, Lordship, he had taken some signatures in the blank papers, Lordship, at the prevailing point in time. Being before that, I could not know him, Lordship.
On the other hand, Mr. D. Burman, the learned petitioner in person, submits that an RTI being made to the 33 number 33 Azara Gaon Panchayat. So reveal and information was given by the president of the state Gaon Panchayat stating on 21/1/2024.
2124, Lordship.
21
120.
or 2/1/2024, stating inter alia that there is no permission given, that there is no objection certificate given in respect to construction of a godown. This court, taking into account the order passed by this court, by the coordinate bench of this court on 21/10/2024, this court directs the GMDA to bring on record the said instruction by way of an affidavit. Mr. taking into account, further taking into account the conflicting reports, Mr. D. Burman, the learned petitioner in person, submits that he would file appropriate application to implead the Azara Gaon Panchayat.
Item 155 at my intention was this statement. Today I have some difficulty. I have to leave my lord. I'll have to leave my lord. Maybe taken up tomorrow on day after.
155, we'll take it up on 15/5. 15/5, 2025. We'll make it properly, 15/5, 2020.
My appeal is pending, so case is,
I'll have it on 155. Don't worry. This matter again, how much time? This matter again on 9th of December. So meantime, steps we take. 155, on 15/5/2025. Okay?
Or it will be disposed of, on single line, my lord. My appeal is pending, so case will be closed, that my appeal will be disposed of and within a reasonable time. Just mark, nothing is
Ready. We'll come back. 3:10, you'll be there. We'll take up 155. Hey, come ready.
Item 22,
Hey, 155. Yes, what is your case?
Can we see page, improved order, page 57 in amended petition? In this order, there is a banning order, my lord, and, 57.
Yeah.
Page 87. And, page 89, further, if you desire to appeal against the order, this order was passed on 8/1/2024. Within 30 days, I prepared appeal. Because of the pendency of this case, appeal is not going to be disposed of. So my wish there is that, let the appeal be disposed of on merits. And, then thereafter, if I agree, I may approach. With
So
this-
you say that as you have filed an appeal against that order dated 17/8/2023, and it is
24.
presently pending.
8/1/2024. 8/1/2024.
Huh?
Amended petition, kindly see. This was, during pendency of this, writ petition,
No,
final-
where's the order?
page,
Last order passed when?
page 87, kindly.
No, how many orders are there? There's only one order of 18/9/2023.
It's the court's order. During pendency of this writ petition, the final banning order has been passed by the department.
Then,
Against that, we prefer appeal,
has it been amended?
amended.
Then has there been any order passed?
No, appeal is pending.
No. After filing
Amendment
the
was allowed,
amended
yes, after
petition-
amendment was allowed, this amended petition has been filed.
Okay, after filing of the amended petition, what has happened?
Nothing happened, my lord. Appeal is pending.
So you filed an appeal
Appeal.
challenging the order dated
8/1/24.
then why did you amend it?
Amendment was, passed because during pendency of this case, my lord, this final order has been passed.
You know, against the show cause notice, they had approached the honorable court. Against the show cause notice, they had come. So there
So
was.
you
no
have
stay order.
filed an appeal against the 8/1/24.
Yes.
And against that appeal is pending.
Pending.
So you want to withdraw.
Not withdraw, appeal may be with the direction to the respondent authority to dispose of my appeal within a specific time. And, with that direction.
When did you file the appeal?
My lord,
When did you file the appeal?
24/1/24.
Then why did you again file an amended petition?
Prior to that, my lord, I have filed the,
No, you filed the amended petition on 23/10/24.
23. No, amended writ petition filed, yes.
Why have you filed here? Why have you filed here and then when the appeal is pending? So you have to withdraw. It's not a question of why should I direct.
No, my lord, initially I have filed the writ petition challenging the show cause notice, which was issued to me, my lord.
Understood?
Then
Final order passed.
final order was passed on 8/1/24.
You filed the appeal thereafter.
Yeah,
Thereafter, again, you sought for an amendment of the writ petition.
it was allowed, my lord.
Understood? So now 8/1/2024 is pending before this court.
Yeah.
Now you want that the appeal should be disposed of.
Yes.
And as such, this
This-
court
This writ petition will be closed, my lord.
will withdraw.
With some of the, yes. I may be, I
Withdraw
may,
in view of the tendency of the appeal. However, this court will observe that the appeal needs to be done because what is this banning?
then,
Amounts to a civil debt, so there is an early necessity for this. That's all. Heard Mr. S.K. Ghosh, the learned counsel appearing on behalf of the petitioner and with Tiwari, the learned senior counsel appearing, assisted by so and so appearing on behalf of the National Hydroelectric Power Corporation. The instant petition was initially filed challenging the show-cause notice dated 17/8/2023. As well as the suspension notice, challenging the suspension notice dated 17/8/2023. Pursuant thereto, an order has been passed on 8/1/2024, whereby the petitioner have been, where's the order?
Page 87.
Cooperative
Whereby the petitioner have been banned
For 2 years.
from of business dealings
Page 88. Page 88.
system. Mr. S.K. Ghosh, the learned counsel submits that an appeal thereupon was filed on 24/1/2024, which is presently pending. He has further instruction from his client that the petitioners would not like to further press the instant petition. Rather, the petitioner would like to avail the appellate remedy which has already been initiated by filing of the appeal. He therefore submits that the petition be closed on withdrawal with appropriate directions that the appeal be disposed of within the time frame, taking into account that banning of business by the impugned order dated 8/1/2024 amounts to a civil debt. Mr. P.K. Tiwari, the learned senior counsel appearing on behalf of the respondent number 2, submitted that the respondent number 2 would duly take appropriate steps for disposal of the appeal at the earliest. Taking into account the above, the instant petition stands closed on withdrawal. This court further observed and directs that the respondent number 2 shall dispose of the said appeal at the earliest. Respondent number, I think that appellate authority will be respondent number 3,
Director project, yeah.
Director project.
executive director. Direction to the respondent number 3, who is the appellate authority, shall dispose of the said appeal at the earliest by giving an opportunity of hearing to the petitioner. The same be done preferably within a period of 2 months from the date of the instant order. From the date a certified copy of the instant order is served upon the respondent.
Item 22.
This is the last order. They were directed to produce the criminal record. The notification, the section 4 and 6 of the.
Well, as I see, there is an earlier land of division, and this one number 4 directed for a Lenovo proceeding, LA proceeding. That was done.
When?
And the award was approved. 2010. Award was approved by the department. In the year
Payment.
2010.
Payment,
There is a requisition made by Deputy Commissioner to the PWD department.
payment, payment made,
Perhaps. But the PWD's name is not shown there, therefore their council is perhaps.
you're not concerned.
They have to
The
say.
state should speak in one voice. Isn't it? You're not
That is
concerned.
the thing. That is the thing.
First of all, in that judgment of the Indore Municipal Board, it ensured Municipal Development Authority is categorically stated that if you don't pay your compensation to the large amount of, to the most of the beneficiaries, then you have to pay the compensation as per the 2000.
Payment has been made. But payment has been made on 17/2015. That payment has, part of the payment has been made in 2015. And of the 1984.
1894.
In
Award passed then when?
award passed on 17/2015. 17/2015.
15.
15. Page for
When
57.
the award?
Page 49.
For 57.
The estimate. Where's the award? Can't be the award. Then estimate.
So this is approved. Approved.
Approved
Then
is not,
the question is,
you see, the approval came only on 5/11, 2015. That means you have to
then
pay
page 49.
compensation as per 2015.
Page 49, this is the approved.
That counts. How do you pass a for or file it under section 12? See, section 11 of
Section
the
11
1894
says
Act.
if the collector passes an award, he has to get the approval from the government.
Where is the approval?
Approval is this one, page
When?
49. Page 49.
No, page 56 is the approval. It missed.
On 5 November 2015.
RTO one was approved estimate.
They could pay compensation as per the 2013 Act. That is,
That's it.
so we shall wait in another 2 years, what we say. But why have you approached this court?
But there is because of this National Plan 2060, that the representation was filed before the Deputy Commissioner to implement the 2013 Act. That has not been done. Malad.
So it is a
Wait,
case of
that-
reference. Because if I start doing it, it will start everywhere.
They should have applied the 2013 Act, my lord. That has not been done. It's apparent, my lord.
Hmm?
2015 only they have approved.
Because the award has become final now. Unless you challenge it. Why should this mid court exercise jurisdiction? Yeah? Because if I open this Pandora's box, every time all repetitions will come here. Go there. I'll observe all these things. Go there. File it. You are entitled to as per this. So you will file a reference, so that reference will be made. And on the basis of that.
that can be
it will
done.
be done. Because what happens if you see the judgment of the, I think it's a very interesting judgment of 2003. Page 656. Sarda Devi. It says that these awards cannot be touched by any other thing except by the civil code, which will be the reference. What, Mr. Possession taken. The first player is useless. Heard Mr. S. Bora, the learned counsel appearing on behalf of the petitioner, Mr. A. Chetty, the learned counsel appears on behalf of the revenue department, appears on behalf of the district administration. The petitioners herein have assailed the award dated 8/10/2015 in land acquisition case number 5/64-65 old, 2/2008-9 new, and have also sought for a direction for directing the respondent authorities to recompute the compensation in terms with the provisions of the right to fair compensation and transparency. Your prayer is bad. As per the right to fair compensation and transparency in land acquisition, Rehabilitation Act 2013, for short, the Act of 2013. This court have duly taken note of the provisions of section 24 of the Act of 2013, and more particularly, section 24(1)(a), which stipulates 24(1)(a) or 1B, 1B. 1B, na? Which stipulates that if a proceedings have been initiated under the Act of 1894 and the same have not, and no award has been passed till the coming into effect of the Act of 2013, that is till 31/12/2013, the compensation has to be paid in terms with section 26 to 30 of the Act of 2013. In the instant case, from the materials on report, and more particularly, the communication dated 5/11/2015 issued by the Deputy Secretary to the Government of Assam Revenue and Disaster Management Department, it is seen that the Deputy Commissioners, Kachar Silchar, have been accorded the approval by the appropriate government. Only on 5/11/2015, which is much after 1/1/2014. It is thereupon the award has been filed in terms with section 12 of the Act of Land Acquisition Act of 1894. Under such circumstances, applying the provisions of section 24(1)(b) of the Act of 2013, the petitioners herein are therefore entitled to compensation in terms with the provisions of section 26 to 30 of the Act of 2013. Accordingly, this court further takes note of the judgment of the Supreme Court in the case of Indore Municipal Corporation, the Development Authority versus Manohar Lal, reported in 2028 SCC page so and so, wherein the Constitution Bench of the Supreme Court observed that once the award has been passed and the possession has been taken, the land vests upon the state. Under such circumstances, the question therefore does not arise of setting aside the award as had been played in the instant proceedings. It was further observed by the Constitution Bench of the Supreme Court in the said judgment that that in view of Section 24(1)(24), the person concerned would be entitled to compensation in terms with the Act of 2013, taking into account the judgment of the Supreme Court in the case of Indore Municipal Development Authority Supra, and it being a law within the meaning of Article 141 of the Constitution, which this court therefore directs the respondent authorities, more particularly the Deputy Commissioner. Deputy Commissioner where? Huh?
Deputy Commissioner Kachar.
Achha, to recompute the compensation in terms with the provisions of the Act of 2013, more particularly Section 26 to 30. And thereupon, make the award and place it before the Revenue Department of the Government of Assam for its approval. The Revenue Department of the Government of Assam is further directed to grant necessary approval, and upon such approval, the same be filed before the court, before the filed, and the award be filed in the office of the Deputy Commissioner. In addition to that, this court, taking into account the provisions of Section 31 of the Act of 1894, further directs the Deputy Commissioner, Kachar, to disperse the said amount to the petitioner. It is further observed that in the circumstance, there is a delay in disposal, in dispersal, and taking into account that the possession has been taken, the petitioner would be entitled to interest in terms with Section 80 of the Act of 2013. Till such dispersal was according with the observations, the incident with petition stands disposed of. This court further directs the respondent authorities as directed herein above to complete the entire exercise within a period of 3 months from the date a certified copy of this order is submitted to the Deputy Commissioner, Kachar.
23 to 25.
Oh. What is this?
What issuing that in lawsuit of the other day, my lord, the records were to be produced.
For what?
Where my lord, my learned friend's case is that he's the first highest bidder. And the verification, the neighborhood verification was not done.
Oh,
Whereas my case is my lord, that the board,
three persons, huh?
yeah, three.
So you will go if you are there. You are the highest,
Is the highest.
but you don't have a neighborhood.
Neighborhood may not, as per notification, they need to have for their practical verification. That did not do it on this respect of 2% that.
You did not submit the neighborhood,
As per NIT, there is no condition matter.
but it is there in 18. As per the notification, and there is a division bench judgment to
Yes,
the
Lord.
effect. So that is your case goes. Your case,
My case was that, my lord, they didn't have the board. The person, my lord, who signed submit the tender, he was not authorized, thinking that the board was not there.
so their board was not there, so I asked for the records for the purpose to see as to whether there was a resolution of the executive officer empowering him to submit. Isn't that the
That
case?
is that, my part.
Is it there?
Okay, without signing of the, without sign of the existing, the explanation.
I'm asking a simple question, whether because at that time, the board was in dissolved. So under such circumstances, on behalf of the board, this is the municipal cooperative society. So 41(6), it is the officer who will function the office area of the board. So whether that officer who have been appointed had issued any order,
Here I got it, here from the record, I got it, got the stamp of the existing register of property society, but without signing.
What?
Without.
Once Simanto Miller Tai was appointed as the clerk. Once Simanto Tai Miller was appointed
Hey,
as the
what to do?
officer.
so Mr. N.K. Kolita, what case you have?
I have the second highest ballot.
You were given, because of the fact that he could not be given, he didn't have a neighborhood certificate. His neighborhood certificate was very much necessary, taking into account the 2018 notification, which is not there. But your thing is that you don't have the resolution.
Actually, file was handed over to me on 11th one. So that is what, that instruction, some paper is not in the file.
That paper is not there, but does it have anything out here? It is Sabhavati Dubru Damor Vibhag. What is this? Resolution of whom? Society's resolution. But was the society not dissolved?
All the were disqualified at that point of time.
So then how can this Sabhavati, how can there be a chairman of the society?
That order have annexed, madam.
That what I mean is. So not, I was, I'm also newly inducted.
I'm also not old here. Yes.
I'm also, but here, going to the fact, I think lot of society is a necessary party. Society is a party. Society is property, society should be a party lot.
And that is different question. I'm only asking, where is the resolution? If it was dissolved, then in that case, who is this Sabhavati? Sampadok is okay. He's the secretary. Sampadok is the secretary. Sabhavati will be the chairman. Chairman, how can there be a chairman if it was under dissolution?
And at that point of time, when the tender was issued, my lord, the earlier board, once it was also already dissolved, it also had completed its tenure. So at that point of time, new body ought to have been formed. That was also not done. So there was no body at all.
Anyway, Mr. N.K. Kolita, when do you want this?
So one,
Hello. But for one week. So you prepare yourself here with a fresh.
I'm already told you, I'm good new.
You said already that you are neutral. I remember those words also.
Actually, he's given a.
Your golden words which has come out from your mouth, I remember that you are neutral. Then I put a question also to you.
What is
That
neutral
don't be so
because
neutral.
I am newly taken, he got. Actually, he got
Okay.
it, when.
The records having been produced by Mr. Sharma and being verified shows that there is a resolution of the cooperative society issued by under the signatures of the chairman as well as the secretary of the said society. Mr. M. Totalan counsel appearing on behalf of one of the petitioners submitted that when the term of the society had already elapsed and there was no new society, and term of the board of the society having already elapsed and there was no board constituted, and there was a one-man committee appointed under section 46 of the Cooperative Society Act 2007. The said resolution so issued, like the said resolution, which was which was submitted by the private respondent, is excessive, honest. And as such, on the basis thereof, there could not have been a settlement. The NK Quinta submits that he has been recently engaged in the matter. And as such, it requires some time to prepare this matter again on.
After 26 on. I mean, this is some medical paper, I. 26. Of like. Item 26.
Yes, Mr. N. Sharma,
Yes, lordship on the last occasion.
you didn't have a case, no?
Yes, yes, the building, the land, our which building is there, but land has been partitioned.
Better find.
Liberty may be granted you.
You don't have a case, because you see, this court doesn't find anything wrong because there is a big mistake, problem which will happen later. Withdraw.
The liberty,
Means with the liberty to, that the withdrawal shall not affect you to take steps as per law. Mr. N. Sharma, the learned counsel appearing on behalf of the petitioner submits that taking into account the provisions of Order 20 Rule 18 of the Code of Civil Procedure, read with Section 54, no, 18, read with Section 54 of the Code of Civil Procedure, and the further proceeding and further the mandate of the Assam Land and Revenue Regulations 1886, the petitioner would not like to further proceed with the instant proceeding. He, however, submits that the withdrawal of the instant proceeding should not prejudice the petitioner in such other proceedings which the petitioner may initiate seeking partition. Taking into account the above, the instant petition stands closed on withdrawal. However, the petitioner it is further observed that the withdrawal of the instant petition shall not affect the petitioner rights to seek partition in any manner.
highly open. 27.
It's permissible. Yes, what is this? Oh, this one, you want to file that? Okay, now tell me, yeah, renew your argument. Mr. MP.
A. Chakraborty.
A. Chakraborty, the learned counsel appearing on behalf of the petitioner submit that he has, that the petitioner have been able to obtain certain documents which the petitioner would like to bring on record by filing an additional affidavit. New documents,
We have not filed the reply yet.
so what? New documents?
But the document is mentioned in the petition that has not been annexed. That
Like to file it in the affidavit in reply. And then it is not old documents. Submits that he would like to file an affidavit in reply to the affidavit in opposition filed. Is this matter after 4 weeks?
obliged.
28. Last petition, lordship, respond number 4 and 5 are directed to file an affidavit in opposition.
What?
Respond number 4 and 5. Silchar Development Council and Chairman were
They
directed,
have filed?
please, not filed. Respond number 4 and 5 are directed to file an affidavit in opposition.
Who?
The Silchar Development Authority, madam.
Interior Development Authority.
Silchar Development Authority. Silchar Development Authority.
Silchar Development Authority.
My lord, I am.
You are. You are not filing affidavit.
No, we'll be filing it, my lord. After 2 weeks, the matter may be disturbed.
Okay, Mr.
Maybe should have.
K. Vishwakarma, the council submits, who appears on behalf of the Silchar Development Authority submits that 2 weeks' time may be granted for filing the affidavit in opposition. List this matter on 9th of December 2024. In the meantime, the affidavit in opposition be filed by 3rd of December.
There is interim order in favor of the petition.
Petition or the past failure shall continue in the next. week.
29.
Wait, it's a law. This relates to the non-payment of the contractual debt. This is the second round of.
Your reply is filed.
Your lordship, the PWD and PWD is required to file the.
Affidavit filed by 3 and 4. Affidavit filed by 5.
Yes,
You
sir.
filed reply.
Yes.
Then what happened?
The PWD is required to file their affidavit, Your Lordship.
PW has not filed. Who has filed?
It was filed by the Sports Authority of India, Authority of Assam and Sport, Youth
4
and
and 5. 3 and 4 and 5. Who has to file?
PWD, Your Lordship.
Okay, none appears for PWD. They don't file, very good. Okay.
In fact, Your Lordship, they have issued me with the work completion certificate also.
Huh?
In fact, they have issued
What did
me,
you make?
Your Lordship, this is the second round of application.
There's some sanction order.
Yes, Your Lordship.
Who has passed? Courts Authority of Assam.
Yes, Your Lordship.
Okay.
The work was executed by the PWD Electrical Division. And it was executed for the Sports
Well,
Authority of Assam.
They issue rule. Let it come up for hearing.
No, Your Lordship,
It is usual cost.
no, Your Lordship, the money is
No,
stuck up, Your
this
Lordship.
amount of time which a suit is required to be disposed of will take same amount.
I am ready with the case, Your Lordship.
Okay. Will issue rule.
Your Lordship will see, Your Lordship, there is a work completion certificate has been issued in my favor.
So
Is-
what?
In spite of that, the payment has been held up, Your Lordship.
The court have to only direct, you wanted to set aside the sanction order.
No, there is no sanction order. Your Lordship will kindly see the page 88, Your Lordship.
And appears on behalf of the PWD on call, which it is further seen that that apart from the respondent number 3, 4, and 5, other respondents have not filed the affidavit in opposition. If a final opportunity is granted to the said other respondents to bring on record their stand by filing the affidavit, list this matter again on 16th of December, 2025. On that day, we issue.
Item 30,
Met result right there. My lord, here last occasion, the final survey report was called for.
Here we have received communication of dated 11/11, madam. Here, my lord, requested to pay for 1 month time, madam, to submit the report.
Which she does the learned additional senior government advocates. Takes another, which you seeks further time of 1 month to obtain to place before this court the survey report. Mr. T. H. Hazarika, the learned counsel appearing on behalf of the petitioner, submit that there is grave urgency in the matter, taking into account that the petitioners have not been allowed to make any construction. Under such circumstances, this court fixes this matter again on 6th of January 2025 to make clear that the responding report is do measures so that the report is placed before this court on the next day.
Okay.
Clear.
51,
I'm told that, my lord, that affidavit has been sent today, my lord, from Karimganj, my lord. We have not received till now. May I pay for 1 week time?
What is the matter, Mr. Das?
My lord, this is also, my lord, in violation of the building permission they accorded, my lord, by the Karimganj Municipal Authority. My lord, the respondent number 6 has constructed his permanent structure without keeping the setback. My lord, page 22 is the permission in his favor. Respond, say, and
Who is
therefore,
appealing for this Karimganj Municipal Board?
We have prepared the affidavit, on behalf of officer, my lord. Chief
Of
Executive.
whom?
Karimganj, my lord.
You are appealing for the Karimganj.
Not municipal board, my lord, that.
Who is appealing for Karimganj Municipal Board?
Yes, it's important,
Is the service complete?
my lord, yes.
You are appealing.
Respondent number 6.
Who is appealing for Karimganj Municipal?
The name of, yes, sir, not for the government
was shown. Subsequently, steps were taken when notice was issued. Junction was drawn. And in 2011-23, address service was completed. The Dawa River report.
Madam, you require some time.
My lord, yes, my lord, one is that.
Because the limit information is on each submits that. Certificate so has already been prepared and has been sent for vetting.
Send.
Certificate submits a week's time may be granted for filing the affidavit. This is matter again on 29th. In the meantime, I think we can find the.
Yeah.
32.
Structured by Mr. P.K. Muni that he's in.
They've not got a single penny.
No, my lord.
Required in it.
You have to apply certain conditions.
Huh?
We've already disbursed the amount, oh no, not this one. The amount has been quantified, my lord, and there is a speaking order passed. So he has to complete certain documentation. So once he completes the documentation, we'll get the money.
We are also praying for the interest part.
But that he needs to go to the district judge. for it.
ND. 10D. This is the petroleum, na?
Petroleum.
Petroleum will be different. It will be under, there is another provision, na? It is there. Anyways, we'll have it after 2 weeks. I think the formalities may be completed.
Yes.
Mr. J. Roy, the senior counsel appearing on behalf of.
IGGL, IGGL.
Huh?
IGGL, in the
IGGL.
gas grid.
Submitted that the formalities for payment of the compensation to the prisoner have already been going on. And as such, some time may be granted this matter again on 18th of December for an update.
Only thing, he has to cooperate with his lordship.
I'm not saying.
Much.
Obliged.
33 and 34.
In item number 34, we are finding the affidavit. I have given the copy to my class, sir.
Affidavit file.
Sir, we are filing it. We are filing it today.
Today.
I have given the copy to my class to sir. Can you pick it up, please?
Both are together.
In item 34, it's a similar item. I am filing
33 and
affidavit in item
34.
34.
You are filing your affidavit where?
In item 34.
Integrated Development Association.
Yes.
The learned council appearing on behalf of the state respondents of this that. Mr. Dina, we are PWD, why you are not appearing in the other matter regarding where Mr. R. Sinha was appearing? PWD none was appearing. The case where affidavit is to be filed. Construction for FIFA, games and all, these have been made and all.
I'll take note of it.
Sports Authority of India. You are not filing it.
I'll take note of that.
Here's for the PWD.
Well, I allotted one of
The thing of the learned council, the government is appearing on behalf of state respondents submits that the state is in the process of filing the affidavit in the one of the. If further submits that this affidavit would take due care in respect to both the proceedings, isn't it? Not. Taking into account above, is this matter again on 4th of December, in the meantime, the commissioner will be at liberty to reply.
I have not yet received the copy. I'll be giving the copy. Okay.
Current case with CBI election.
Oh, hello. For CBI for what?
Silchar PS case number 2558 of 2022. She was missing, the petitioner daughter is missing since 24 of October 2022.
Now tell me, why should this court order a CBI investigation? They are taking steps, unless you say that yes, they are not capable of. But the fact that they are taking steps, what to do? File your reply. File your reply against that and point out what are the defects, what they have not done. Then only I can direct the CBI. You want the CBI investigation?
Yes, that's right.
Because the CBI recently also, the Supreme Court said that it is only in these circumstances you can. So try to bring your affidavit within that. Yes. The recent judgment is come. Mr. So-and-so, the land council, each country, the land council is willing on behalf of the government, supports that we may granted some time to file the affidavit in reply. To discuss matter again on 9th of December. The meantime, the affidavit is filed. Take out the judgment. Yes. Then on the basis of that, those grounds.
That's it. I know someone's name to be shown in the first list, Nelson.
Huh?
CBI counsel Manasa's name to be.
We can also see that the Central Bureau of Investigation is not preventing. This will show that M. Hello, the standing counsel of the city.
Okay.
Yes,
36.
I please your lordship, last occasion, GMC has took time to file affidavit. Respondent number 4 has filed affidavit. We have also filed our reply, but GMC has not filed their affidavit.
why you are not filing?
You know, file my affidavit, but they have admitted there is a deviation manner, they have filed an application for regulation.
No, no, lordship.
Basically, they say that they have already filed an application before the GMC to regulate. The petitioner.
No, lordship. The Honorable High Court on as per order dated,
What are you challenging, madam?
lordship, demolition some portions of the building, lordship.
They've demolished.
They have not demolished, I myself demolished from the front side, but because they have pressurized us, they have repeatedly come to demolish our building on the basis of the complaint, lordship. Actually.
How much is the deviation?
Lordship.
How much? Just
Lordship.
tell me how much?
He says, some are compoundable and some are non-compoundable, lordship.
For GMC, everything is compoundable. Don't worry. GMC can compound G2 plus 2 to G plus 7.
We have all the permission, lordship,
Then,
but they have come to,
please
Hello.
see everything. Yes, see.
yes, yes.
And have you seen the recent judgment of the Supreme Court? Wherein, as regards demolition, pressurized demolition as well as demolition, cost of 25 lakhs have been imposed. Look into the judgment, we imposed 25 lakhs of recent judgment. That is the last judgment of our personal Chief Justice, the last judgment. On the question of demolition, maybe for widening of the road, but then also.
We'll find out, I'll find out.
So they have filed an application on 29th for regulation.
Regularity,
They themselves say that there is deviation manner.
No, 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 I have not said, lordship.
they are saying it is to be compoundable or deviation.
That. Compoundable.
Compoundable deviations, you have to do it.
But they have pressurized us in my picture.
Don't get pressurized with GMC. Nothing is going to happen. Come and file these petitions before this court. All matters of GMC, right? Don't compare, means get pressurized with it. Nothing is going to happen.
I have already demolished my front side lordship from their pressure. They come with.
Now what do you want?
They just set aside the notice lordship.
Ah, this. You won't do anything. You gotta stay.
Yes, lordship.
Just you make it until further.
I'm sorry. I have already filed.
Not part of the period of filing an application for seeking compounding. So accordingly, they've gone for compounding. Where's the stay? Since the court is in session of the matter,
Lordship,
let the GMC not take any action against the impugner without the leave of the court.
Yes,
So
sir.
no leave has been taken.
No.
So Ms. So-and-so appearing on behalf of the petitioner submits.
Madam?
Submits that an application has been filed for compounding of the for compounding of the deviations before the GMC authorities on 29/5.
Received on 29/5/24.
Mr. Ezbora submits that such applications have been duly received and the GMC is considering the same. Accordingly, let this matter be again listed on 10th of February 2024. 5.
Much of them.
Yeah. What case here? What is?
The matter with renewal of vending license. The railway catering policy.
And the matter is subject to decision of the Supreme Court because the
Get it either transferred or anything. This court is not going to
No,
touch.
sir.
There is another
Simply
matter I
one
have specifically passed in order to take care.
There's a recent judgment by which
Supreme Court has granted the order.
our
It has-
recent judgment of the High Court Malot by which the catering policy was upheld.
It
That
is not the matter. Matter again the eviction, your lordship. And he is showing another judgment. Kindly have the judgment of this writ appeal, your lordship. Writ appeal.
Oh, this is the last one.
Writ appeal, your lordship.
Dismiss.
No, no, it is not that matter, your lordship. Writ appeal is here against the order dated, your lordship. 12/8/2024. This matter doesn't cover with this. And it is still pending. There is the 10th December 2024 is there. They are showing different orders. That is not the party there. NF Railway is there. Lumping division is here, your lordship.
the issue is same.
No, not same. It is against the eviction. It is not for the renewal of catering, your lordship. And already 10th December is fixed before the Honorable Apex Court, your lordship. And no objection has been filed by the railway there. No objection has been filed. And this is matter not with the lumping division. They are showing.
Where is your appeal?
Hello?
Where is your appeal before the Supreme Court?
Appeal, your lordship. That is mentioned in the order dated.
No, forget about this.
Yes, your lordship.
Where is your appeal before the Supreme Court?
SLAC number 7.
No, give me that order.
My lord, that order, your lordship.
Ah.
Just now, your lordship. Kindly grant me some time. Your lordship.
But
Follow.
anyway, I am not going to pass any order.
My lord, kindly pass. Kindly fix on that, your lordship.
The issue relating.
No, no, not at
No,
all.
no.
It is not. Issue has been noticed,
See,
your lordship.
thing is like
No
this.
counter has been filed by the bill.
I did not pass an order. The division bench also did not pass an order in view of the passing of the order by the Supreme Court.
Yes.
So whether the Supreme Court order has any relevance or not. So And she has not produced this order for the Supreme Court, where there is a stay.
No, no,
In fact,
No,
if I
no,
remember
only
correctly,
10 minutes, your lordship.
if I remember correctly, isn't this a case where initially they filed with petition?
Against
I think this was done by Justice,
the eviction order, your lordship. 15,
Justice
Your Lordship
Michael
have
disposed
rejected.
it off, dismissed. Matter went to the division bench.
one.
Division bench went, division bench also dismissed. Matter
Not
went to
dismissed,
the
disposed
Supreme
of,
Court.
your lordship.
Supreme
Disposed of
Court
with
said
observation.
that there is another order being passed by another bench, that is by Justice, Simple and another one. They passed an order where there was a permission being given for the purpose of asking them to file an affidavit in another matter, no, a representation. And thereupon, in then nothing is to be done. So therefore, they sought for a review. The review was filed, the review passed similar directions. After this passing of the similar direction, they came up before this court. When they came up before this court, I did not, after disposal of the representation, I did not do anything. Thereupon, in the meantime, the matter also, when I didn't do anything, the matter again went to the division bench, SLP was filed. A bench comprising of Justice Dipankar Datta was sitting, where he said as to whether after a withdrawal of the liberty to file a review can be permitted and wouldn't it be barred? And as such, this is the situation. Isn't it the case? Then what case you have? No case.
Hello. There is the, your lordship, grant me 10
Whoa.
minutes time, your lordship. I kindly pass over, your lordship.
Who are them all?
Because it is subject to your lordship.
I'm not passing any order. I didn't
Fine,
pass any.
fine. That-
I'm not passing an order because he has not produced,
No, no, your
he has
lordship.
not produced
Just
any order.
That I am asking only 10 minutes time, your lordship. Earlier, on earlier occasion, your lordship, I have supplied to you on 9th September, it was, kindly have your order data, your lordship.
No.
Your lordship have passed the order on 9th September. After seeing the
You
order,
do one, Mr. Gupta, you do one thing, you want to file an affidavit? File. It's the matter of 4 weeks. Then the status, the respondents will get liberty to file it. So this I will be requiring for another matter. Because there is another stay which has been granted in another petition in. That is of, what is the name, with another party, what is the name of the party? Some Ghosh.
Catherine, yes.
It's another matter
Yes,
which
there-
went to the Supreme Court, where there is, no, not in Ghosh, there is another matter. Anyway, this I require for another matter. I'm keeping it.
There are 4 matters. In fact, there are
Ah,
3 to 4 matters are there.
Yes. I'm keeping it.
But more the issue is similar
no,
here.
no, not at all. your
She
lordship.
doesn't have anything. In fact, you
Not
need
at
to
all,
get a
Your Worship.
clarification. You should have in fact informed the
Madam, they have
division
to
bench
file the
about this
counter
thing,
deed
that
to
there could
object.
not have been any.
Fine.
There's no stay.
And some date will fix. Your lordship, some date will fix. If any.
No date fix, no date fix. These type of matters, no date. Fix. Go to the division bench again to get a thing fixed. Yes, next.
My name. Deep Lord.
Direct to file an affidavit in opposition.
Yeah.
And there is also internal.
What is the matter about?
So regarding the assistant settlement officer who
Yes,
exceeding his jurisdiction and entertaining the petition of two private individuals.
we stayed it, na? We stayed it on the last occasion.
The senior, the council who engaged us, his mother expired, so we did not contact the
You are paying for?
respondent number 5, private respondent.
Not with five. About the state respondent.
Respondent of
Why you are not taking any action? Recall these type of orders. What is these type of orders? You know, civil disputes are going on or nothing out there. And fine morning we exercise these type of rules, completely beyond the jurisdiction. Court had perused the annex AI primacy of the opinion that the assistant that should not have exercised the jurisdiction in respect to the subject matter of the complaint. This will state the proceeding insurance. You said proceeding there on the basis of a complaint filed by friends. Because of these assistant settlement officers, why don't we close the courts, civil courts? Let them be the civil courts. The council appearing on behalf of the respondents, more particularly the district administration, submits that some more time is required for filing an affidavit. Full stop. List this matter again on 14/2/2025. In the meantime, both the state response district administration as well as the private response will be on the progress time. Interim order passed earlier shall continue till the disposal of the. Not sure. Till the next.
This item 40 to 135.
Yes, tell me what is your case,
Lordship,
what you are asking for.
for my learned seniors in my lab, after the last hearing, my lord, I had a discussion with the clients.
Now tell me, how are you entitled to the compensation?
My lord, my lord, the land was ours. It was occupied without any acquisition proceedings. I've mentioned, sir, though I have taken that fee, but I have not made any trade for compensation for acquisition of the land. Because the land was never acquired. It was only the Zirat compensation for the cocoa patta, some non-timber, forest produce and all that were assessed, and certain amount has been paid. But the assessment was incorrect. This was again revised and re-revised. By the time in 2019, they applied the provisions of the 2013 NARR Act. My lord, what I would like to say,
Whether there is an award,
there is no award, there is no notification, no declaration.
so there is no proceedings under 2013 or 1894, nothing.
Yes, my lord. It was based only on an agreement.
My lord, that is why, my lord, I had a discussion with my clients. If lordship permits me, may I be permitted to withdraw these petitions with the liberty to file infringement? Because we would have to challenge the occupation without any action. I have taken certain pleas in my petition, my lord, but I have not challenged
You want to withdraw the entire,
my matters, my lord, not Mr. Burns, in which I am involved.
which are your matters?
My lord, item 44, 68 to 110. 44, 68 to 110, 114 to 129, 133 and 130. 68 to 110. 114 to 129.
So what are you challenging now? What you would be challenging?
The occupation of our land without any acquisition. Because if they want to occupy the land, they have to acquire it as other based deliberations. So since there is no acquisition proceedings, they cannot occupy that. Therefore, my right to property has been violated without there being an end. I would like to challenge. Here,
So you
in
mean to
this-
say
in
that
these-
there is a formal defect in these petitions, taking into account or the petitions have not been filed in proper advice, legal advice, whereby they have sought for certain compensation, assuming to be a compensation within falling under the Land Acquisition Act, without the land being at all acquired.
Formally, my lord. Now, my lord, this compensation assessment was made by the duly appointed board.
Why these matters have been brought here?
Certain matters were filed there. Thereafter, there was an application for transfer from the NHPC's was transferred here, and thereafter, Honorable the Chief Justice on the administrative side directed all the matters to be transferred to the principals.
Actually, my lord, this item number 41, 5402, my lord, am I audible?
Yeah,
Yes.
and
My lord,
distinct.
actually, this item number 41, 5402 was filed at Guwahati and challenging this issue. And in the meantime, since this
Mr. Tiwari, have you filed anything?
My lord, our main writ petition is 5402 of 2020.
That's your
This was
petition.
the first petition,
No, is it your?
540. And in this writ petition. my lord,
Wait,
the previous
item number?
Item number is my lord 41.
41 to be there.
In this writ petition, my lord, the scope is, we have challenged the second loss assessment report, the third loss assessment report, and its revision by applying 2013 Act, making it an amount of more than 3,000 crores.
So this 5402 is there.
Yes, my lord. That's our writ petition where the pleadings are complete.
This is okay. Now,
And
what
in
do
the
you
second-
say? What do you say about his prayer? Hey, listen to me. His prayer for withdrawal.
uh, He being a petitioner, the
No, no,
documents
no.
which is-
This is not a simple prayer for
I
withdrawal.
understand. He
The
wants to-
prayer with a liberty. Now, what he has done out here, that he is asking for certain compensation on the basis of some agreement on, which have been calculated on the basis of the right to fair compensation act. He is asking. But the fact that there is no acquisition proceeding, he therefore submits that he would like to withdraw the instrument petition and then proceed on a different line, that there being no acquisition proceedings at all. The appropriation of the Jirat as well as the land by which the possession has been taken, bad in law, and accordingly he is seeking for compensation.
But the first part would be the limitation, because
You see
If it
Tukaram,
is legal,
Tukaram's
that's
case, Vidya Devi case, no limitation.
then the second part of that case would be, there are affidavits of the state of Arunachal Pradesh in the Goda Varman case filed before the Supreme Court, wherein so far as the status of USF land is concerned in the state of Arunachal Pradesh, and this is very much part of the record here, the competent authority passed the order saying that in our affidavit, we have taken a stand that the state of Arunachal Pradesh, that is the government has got exclusive ownership over the USF land. Here, the land was divided in two parts. Number one, it was a proposed reserve
No, no,
forest.
no. That is a question of merits in that. I'm not saying. Here, withdrawal is no problem. He can. On the question of liberty, I'm asking.
It's like, between the devil and the deep sea. To answer this question, I find myself between the devil and the deep sea. If I say,
That is
Liberty
why I'm
must
putting
not
the
be given.
question. Huh?
if I submit that the liberty, Lordship may be pleased not to give him the liberty, then the reasons have to be given for that.
Yes.
And the
Because
reasons.
he comes up with this thing, whether each case is maintainable or not, it is another aspect of
Yes.
the matter.
That I would be on the maintainability.
No, that case is maintainable is another question of the matter as to whether these people have the right over the land, whether the Arunachal Land Act would have prevailed over that in respect to areas where the person is not in occupation. These are various other aspects of the matter which will be questions of. But the fact that he has a right to allege that his land, he has been deprived of his land which belongs to him, and without there being any acquisition process.
Taking his submission as it is, and we have to, take it as it is. Because otherwise, we have to enter into the marriage which we cannot at this stage. the only may not possibly, perhaps not the only argument could be whether at this belated stage, being wiser, whether such a plea can be taken and whether on the ground writ petition should be allowed to be withdrawn with liberty. Because apparently the only argument can be it was on an incorrect legal advice that petition in the present form was filed. But my lord, many years have lapsed by now. And it was way back in the year 2009 that in terms of the first loss assessment report, the money was paid. So after
No,
2009,
initially the petition was filed when?
it was sometime in 22 or 23.
No, 24. These petitions are filed in
They were
2020.
renumbered.
Huh?
They were renumbered. Many petitions. were
No.
renumbered.
It has been renumbered here as also in 4/9/2024, but otherwise it was, the number was 420. In 2020. So it is not there. The question of delay is another aspect of the matter which can be very well taken into consideration at a later stage. But the Supreme Court in 2-3 judgments categorically says that when it is a violation of 300A, the question of delay doesn't help. In fact, in the
No,
recent
no.
judgment,
It has been elevated to the level of fundamental right after the recent judgment. The right to property. The very concept of socialism has been transformed. Though there are dissenting judgments, of course, but not on the principle, on other aspect. The old Krishna Iyer doctrine, but now private property, yes.
let us keep it to a human right.
These days are different. Days are different. Those days were different.
No, one has to, however, they duly take note of. You see, there are varied aspects. We are taking up this bench 4-5 out here, more particularly bench 5, lots of land acquisition matters. Every day I have been disposing of so many land acquisition.
This is one of it.
Now, the fact what is there, till date, there seems to be the, what you call, the effect of the 1894 Act or the power of eminent domain, which is there with the state, that still, yes, in some cases, selected persons get it, there's no problem. But in respect to others, we give you here no solution. The law is very clear, but then also no solution, nothing, no interest of 12, nothing. There's nothing out there, and they have to come. They know it very well. In a case of 2015, if you are doing it, the award being passed, isn't it very clear everywhere? They still do it as per the old days. So let them go get harassment, do whatever. This happens to the common people. But it is still going.
Here, the doctrine of eminent domain is not in doubt. But what exactly is it the challenge is, fine. Under eminent domain, you have the power to take the land for in public interest. But well, give us, it should be properly acquired. Whether acquisition, the very factum of acquisition proceeding not having been carried out, whether ipso facto it would be an illegality. Therefore, the whole entire proceeding would be a nullity, would be an issue for the consideration of my lord. And then, of course, that's a very facet of merit. And difficulties have arisen primarily because in the state of Arunachal
But if you
Pradesh,
see,
the landlord self.
if you see the judgment of the, I think the partly dissenting judgment of Justice Nagaratna, in that 7 judges, you find there are various modes by which land can be acquired. So, to vest the title upon somebody, one has to do it within these modes. These modes are very relevant. Maybe the judgment may be different or out there or partly dissenting, but these are various modes which needs to be looked into. There are many cases where you find that we just take it, but where is the title conformity? If you see the Indore Development Authority judgment, there is another very interesting aspect here. In fact, to the effect that even 11A, I find it difficult to take it. 11A says that you are to give the award within 2 years, else it will lapse. You have to take note of. 11A came subsequent to 16. But there are certain judgments which were taken into consideration, wherein it says that even if the possession has been taken under 17(1) or 16, and the award is passed, it bears, so 11A would not apply. These have been reaffirmed in by the Constitution bench in the Endowment Development Authority. Although there are many more judgments later on also which says that no, it cannot because it lapses. Because of the fact that 11A is a later legislation.
Perhaps, so far as Indore Development Authority is concerned, that would not help them in this case, in the present case. For the obvious reasons.
Well, first of all, Kuchun doesn't know because there is no legislation.
Natural.
But these are various.
Various facets. That's true. That's true. That's true. And that's why, it would be quite a fascinating exercise if my lord deals with these cases. The kind of question that will come from the lordship.
Before dealing with the Nair has just walked out.
Again, the matters may come before my lord because
Well, let the
Anyway.
NSPC file their affidavit.
Let us not pick up. Wait. Which are your matters,
Madam, 44,
Before
68 to
Take a look.
110.
Huh?
68 to 110.
110.
114 to 129.
Okay. Then
133 and 134.
168 to 110. Then
114 to 129.
129.
133 and
And
134.
after 129,
133, 133
and 134.
and 130. Total 60.
Mr. P.T. Nair, Mr. P.T. Nair, the learned counsel appearing on behalf of the petitioners in the instant batch of the petitions. Submits that there has been no acquisition proceedings initiated under the applicable provisions of law. He therefore submits that without there being a valid acquisition, the land of the petitioners, as well as the benefits arising out of the attached to the land, as well as arising of the land, cannot be appropriated by the state without without following the due process. He, however, submits that on a completely wrong, on a completely incorrect legal advice. These petitions have been filed seeking compensations. And as such, the petitioners, he has been instructed by the petitioners to withdraw the instant writ petition. He therefore submits that the action on the part of the state to appropriate the land as well as what has been attached, what were attached and arising and benefits arising of the land being illegal. The same, the petitioner be given the liberty to challenge the same and be allowed to challenge the same This court, during the course of the hearing, had also inquired with Mr. B.D. Goswami, the learned additional Advocate General of the government of Arunachal Pradesh, as to any award, as to whether any proceedings have been initiated under the applicable acquisition acts. The learned additional Advocate General submits that to his instruction, there is no acquisition proceedings initiated. However, there were certain attempts being made to make these settlements so that the people as well as the taking into make settlements so that the project of the national, what is that? NHPC. What is the full form?
National Hydroelectric Power,
Project
National Hydroelectric Power Corporation.
could be
So NHPC is an abbreviation. National Hydroelectric Power Corporation.
set up. Mr. P.K. Tiwari, the learned senior counsel appearing on behalf of the National Hydro Power Corporation Limited, submits that the state that submits that his client has filed a separate petition being WPC number 5402/2020, 5402/2020, which is presently pending. He submits that as regards the withdrawal of the petitions, as regards the withdrawal of the petitions, he has no objections. However, the liberty so granted should not be such whereby such petitions, the liberty so granted shall be subject to the maintainability, keeping the maintainability of such writ petitions open. Taking into account the above submissions, this court closes this batch of writ petitions on withdrawal. This court further grants the petitioners the liberty to challenge the actions of the state authorities as alleged to have deprived the petitioner, the purported exercise of the state authorities to deprive the petitioners of their land, as well as the benefits and whatever benefits arising out of the said land. This court, however, the granting of the said liberty would be subject to keeping the maintainability of the writ petition open. Yes, now you are okay. Tell me. Now I can't hear your voice with Mr. Nayak on. Tell me.
Look, am I audible now?
Yes.
Am I audible
Now,
now?
tell me.
Am I audible now, my lord?
Yes, very much.
My lord, my respectful submission would be that, my lord, the agreement between the deputy commission people of
Your item is which one?
item number 40, 42, 43, 45,
Okay, give me
67.
40 item. Give me item number 40.
Yes, let me, yes, my lord.
Bokma Hole.
My lord, yes, my lord, there was an agreement between at page 34, my lord.
What do you want?
My lord, I want that
Number 40 to do. Hold it. Hold it. It is it is me. What is the solution? 40 is actually what is the solution? Even know, I do 41.
at the number 40, my lord. My lord, actually what had happened is in the first assessment report, only 8 species of trees, tokopata and bamboos, only in the land, it was calculated.
Hey, does it take such a long time to get me item number 40? Repetition number 4971. Just now you have taken. I have given it back to you. Imatro mo grade issue. File 2. Diok na ito. Okay. Yes, tell me.
Yeah, my lord, by this agreement, in close page number 34, my lord.
Yes.
Page number 34, close 8, my lord.
Hmm.
Page 35.
Hmm.
The compensation of land, tree and other immobile properties shall be paid by the NSPC to the landlords after due assessment
This agreement
verification
is between whom?
between the NSPC and the people of
Of
Gengi and
village.
Siverite. Yes,
Okay, then
affected people. Now, my lord, since there is an indication of acquisition of land, and then, my lord, at page 96, page 96,
who has
annexure
signed
6,
on behalf of NHPC?
my lord,
Nobody.
here
District Commissioner.
name is not there, but my lord, they have
No, no.
signed, and the
There's
deputy
no
commissioner has
signature of
also
anybody
signed.
from NHPC.
Deputy commissioner has also signed.
How the deputy commissioner can sign on behalf of NHPC?
No, 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 no. Not on behalf of NSPC, but
Ah,
they have signed.
ah,
It is undisputed, my lord.
ah,
They have never claimed that they have not signed.
ah. Now it is under whose possession the land is?
Now it is in their possession. Now, my lord, at page 36, the chief engineer civil of NSPC,
Ah,
he had signed, but at page 36,
ah.
on the left side, my lord. Then senior manager civil, then manager, environment officer, these four persons on behalf of NSPC, they have signed. And on top of that, my lord, there was an MOA between the NSPC and the government of Arunachal Pradesh. My lord, apart from this agreement, there was an memorandum of agreement between the NSPC and the government of Arunachal Pradesh. My lord, clause 3.1, may I take your lordship to annexure 16, page 96, and particularly page 97, my lord. Malad, the agreement between the NHPC and the government of Arunachal Pradesh, Malad. Here also, they have provided that the land will be acquired. And just because the provisions of 1894 Act was not followed,
Mr.
Malad, for
Counsel,
that,
Mr. Counsel, listen to me.
Malad,
I think you, like Mr. Nair had done, you need also to file your proper petitions. Challenging your land has been taken without paying you the compensation.
yes. Now, Malad,
Violation of, you said violation of 300A. It's okay. But unless there is a direction, how will the land, rights of the land vest? And if the land of the right of the west does not vest upon them, why will they pay?
Malad, the land is already submerged.
Understood. Submerged or not submerged, I am not concerned. But because of the submerging, they have taken the possession.
Yes.
If they have already taken the possession prior to that, without any acquisition proceedings, there has to be an acquisition proceedings to give you either acquisition proceeding or purchase.
Malad.
That's the only way out. Somehow you are to be redressed. But,
Malad,
but who is going to redress you? How can you be redressed? How can in
Malad.
each case this court can look into it that yes, you are entitled to these, that you are the owner of this land? Tell me, 226.
Some mode of acquisition, calculation of the compensation was undertaken. And Malad, this has,
How can
it
they
has,
pay? Why will a compensation be paid unless rights have vested upon them? They may be in illegal possession. But the right have not acquired upon them. If any right is there with you.
no, Malad, at this stage, again, raising that issue may not really serve the purpose because we will not get back the land because it's already submerged. Now,
Understood. You may not get back the land, but the question of getting the compensation, how will you get the compensation?
no, Malad, since they have undertaken this assessment and they are duty bound because they have entered an agreement between the NSPC and the government of Arunachal Pradesh. They are also they are supposed to acquire the land, but then somehow the actual process under the Land Acquisition Act was not followed. But just because of that, we cannot be made to suffer, my lord. We have been denied our rights. So now, since the district
But
collector
tell me,
has made
how
that
will the
assessment,
court, now how will the court direct payment of this amount without conveying the title upon them? Tell me, give me a good idea.
no,
Let me also be knowledgeable from you.
no, my lord, it will be deemed to have been transferred
This amount
once
which
this
you
is
are
paid.
claiming, Mr. Counsel, is on the basis that you are going to convey the title also.
Yes.
As regards possession they have taken, but you are also going to convey the title.
Yes.
Now, how will you convey the title? Tell me.
No, my lord, it will be
Are you
because
going
of
to execute a sale deed?
Hmm.
Somehow the title has to be conveyed. Otherwise, their possession would be illegal at best.
Yes.
And for
Their
illegal
position is
possession,
illegal.
no,
Madam.
Mr. Counsel, if I say so, they may at best be directed to pay for illegal possession.
My lord.
I
No, my
cannot
lord,
direct them for payment of this amount unless there is an acquisition or somehow the title is being transferred, or that I direct them that if you acquire the land, because you cannot take the land in this manner.
Yes.
That is what Mr. P.D. Nair did. He wants to file a petition saying that, look here, you have taken my land without due process.
My lord.
And as such, the due process can be either by rehabilitation, restitution, That is there. But for that, the title has also to vest.
Yes, legally.
Yes, it is something like today that in one of your house out there, of the many houses, in one of your houses, one person enters into it and is residing out there. Are you going to ask for the entire house money,
Hmm.
property value, or are you going to ask for the rent?
No, my lord, in that case, let me have a further instructions from my client.
Test. When?
My lord, give me at least 2-3 days time.
Enter. We'll have it again on 2019, 21st.
21st of November.
There is more than 3 days.
Yes, my lord. Item number 40.
Okay, all
42.
matters, all these matters will go on 21st. Okay.
My lord, one more, my lord, WPC number 3577 of 2023 also, my lord.
We'll have all the
35.
other matters on 21st. Let us get them from these people because you see, there the problem arises. Somehow one has to pass that direction, then only it will happen.
Including, my lord, WPC number 3577, my lord. Another case is there which is not listed today.
Oh, some of the cases it seems have not been listed, is giving a different number, which is not in the list.
3577.
By a separate order, various repetitions have been withdrawn. Various repetitions in the instant batch of repetitions. Various repetitions. Forgot to put this. Elegant. A बाकी matter given. On hearing the learned counsel appearing on behalf of the Mr. P.P. Tiwari appears on behalf of the petitioner in WPC number 5402/2020. He further appears on behalf of the respondent NHPC in the other petitions. Mr. B.D. Goswami appears on behalf of the state, the additional advocate general appears on behalf of the state of Arunachal Pradesh, and Mr. R.K. Dev Chaudhary appears on behalf of the Deputy Solicitor General of India appears on behalf of the central government. This court have also heard Mr. M. Patil,
P13, my lord.
P. Patil, the learned counsel appearing on behalf of the various petitioners. Upon hearing the matter at length, this court had put a query upon the learned counsel appearing on behalf of the petitioners. Put a query upon Mr. M. Patil, the learned counsel appearing on behalf of the various petitioners, as to how the petitioners would be entitled to the compensation as sought for in the petitions without the vesting of the rights, if any, of the petitioners upon the state or the NHPC. The learned counsel submits that he would reply. He requires 3 days time in that regard. Leaves these matters again on 21st of November.
My lord, WPC number 3577 also maybe.
He further submits that in addition to the instant batch, there is another petition being WPC number 12. The registry shall also bring on that.
Lord, at least I'll be clear once these things are sorted out. I'll be clear at least where do I stand after these petitions are sorted out. Because in 5402, my scope is entirely different. I am on the second and third loss assessment report,
So
and it's a retrospective revision.
So half of the matter
Yes.
is finished.
Yes, yes.
Remaining half we'll see on the.
It would be quite a experience before my lord, at least in these kinds of cases. Because I'm already preparing myself for the likely questions that would fall from your lordship.
Obliged, Lordship.
Yes.
Item 136.
Yes, Mr. BK Ghosh. Read this issue notice making it returnable, PG5. Whoever would observe that although respondents can very well speak about the possession in terms of. Yes, what has happened?
My lord. In this case, my lord, though I understand.
Instruction? Have you thrown out the petitioners?
We have not thrown out.
I don't know what I really submit my back.
But only,
Something like that, my lord, because
only, my lord. We are giving them is a 2 weeks further time
No.
we will launch it and no more, my lord.
To whom?
When
I'm not there. What was my order? My order is very specific. This court, however, would observe
Yes, yes,
that although respondent can very well take over the possession in terms with section 3E of the Act,
that's clear.
the respondent authority may provide some reasonable time to the petitioners to shift from the present. The reasonable time so mentioned would depend upon the exigency of the respondent authority.
This is a 110, that is 30 days, 43 days each. As on that we have given from date out.
No, I am not passed any interim order. I said that you give him whatever means.
my lord, that was,
How much time he has got till now?
43 days from date of.
Oh,
my lord, to acquire the layout, we have started construction here in Mabad. My lord, worship will kindly prepare. This is my lord, the
nothing remains. What? What do you
workshop,
mean,
my lord,
Secretary?
plus, my lord, my, everything is, every materials are there, my lord. Because this is a Maruti Villa shop, of entire Borak Valley, as well as, my lord, Karbi Anglong district, my lord.
Mr. Counsel,
Lost, I understood, my lord.
I made it very clear. They have not done anything. Let them do it. Therefore, I'll make it clear that this court had not passed any order by which their NHAI has been injuncted. So they can very well proceed as per their
We have also filed an
Immediately-
application, my lord, for extension of time, lord.
to stop.
They may consider this also, my lord.
That is your, they may
Why not? Yes,
consider
they may
you,
next time,
you have a good rapport with Mr. Seabover, he may consider many things, but not for this
Consider-
hospital. To stop. Mr. Seabover, the learned counsel appearing on behalf of the NHIDCN submitted that taking into account the order passed by this court on 1/10/2024, this court, the NHIDCL have not disturbed the possession of the petitioner. He, however, submitted that from 1/10/2024. Now, he, however, submitted that the 3E notification was issued on, any idea? 3E.
Three notification is not there. Three is there.
3E,
Three is not there.
there will be.
They will,
No, after 3D, when is the 3D?
the notification in my, under my instruction, three not has been issued by.
No, not necessary to issue notification. But when was 3D issued?
Then take it, ID. When I.
There's a date, no, 3D. Where's the 3D? No idea.
My lord, yes, it's 21st July.
If I submitted that the 3D notification was issued on 21/7/2024. And on the basis thereof, in terms of section 3E, the possession could have been taken.
Only the problem, Ali.
He, however, the Mr. Sivuru further submitted that even after the order being passed on 1/10/2023-24, the petitioners are still in possession for almost 43 days thereafter. This court, upon hearing the learned counsels appearing and having perused the order dated 1/10/2024, had not passed any order restraining the NHI DCL to take actions for possession. A request was only made to afford reasonable time, that too depending upon the exigencies of the NHI DCL. Under such circumstances, this court fixes this matter again on 16 December. 16 December. 16. Full stop. It is made clear that this court had not passed. This court had not issued any order restraining the NHI DCL from taking over the possession. I'm giving 16-12 means you will give them. If I fix earlier, you will throw them out.
Only the problem.
But so that don't, I'm making it clear, this court had nothing to do.
I don't, the only the problem. If it is the second case,
Absolutely
then
no. Then you do one thing. Every month, pay the rent to them. Pay the rent. What is the value of that building? Pay them every month.
That is correct.
And and in addition to that, if the given is that 5 lakhs per month, you're going to pay. It is actually, it is his property now. He has paid you everything, and now you don't want to give up the possession. No, nothing doing. Ask him, ask them more money. They'll also indicated that where these people. Oh, this is a very important matter.
Hello.
Yes, where is the revenue? Not you, revenue. No revenue council. Let us have the commissioner and secretary revenue because he is the main person. Where are you going to keep these people? You have thrown them out, saying that these are tribal lands. Fantastic. But where will these people go? This is the welfare state. This is what we have asked you. This is the matter on 18/11/2024, taking into account that none has appeared on behalf of the Revenue Department when the matter is called for. This court grants an additional opportunity to the Revenue Department to bring on record their affidavit, failing which appropriate orders will be passed. Inform them.
M148.
Revenue Department is not good. Taking into account that the Revenue Department is not represented, this matter again on 19th of November 2024 at 2 p.m.
49.
Yeah, please, the lots. Lots of this case has been restored, my lord. Earlier it was disposed on by order dated 11/9/23, and by the after that we have filed a contempt petition, and the government have filed.
Oh,
a appeal, my lord.
this one.
So I'm praying for.
I
1 week
asked
time
you to file an
I am for
application.
treatment, my lord. 1 week time, due to some problems.
Council appearing on behalf of the petitioner seeks for 2 weeks' time to file an application for implement of the Ministry of Jal Shakti.
The Union of India and the NHIDCL.
For impleading the central government as well as the NHIDCL. List this matter again on 11th of December. In the meantime, the affidavit will be filed, the application will be proper. No, so list these matters after the filing of such application.
The government they filed the affidavit, my lord.
What about the government? Your problem arises there. If I am there, I will finish it off.
150.
After filing of the file.
You have filed the affidavit. With the limit, additional senior government advocate submits that the affidavit has been filed pursuant to the order dated 3/10/2024. So, list this matter on 11th of December 2024, along with the said affidavit.
You are.
What is this?
My lord, regarding my lord, that
Huh?
they filed the affidavit today, my lord.
What is the matter about?
My lord, about regular, my lord, policy amount, my lord, it's
Huh?
husband, my lord, died, my lord, there are three policies, my lord, against this. That husband, my lord, that has been not written to me.
Provided, oh, the LIC, respondent shall not disburse the sum issued against the forfeiture policy to the respondent number 7. You, 7,
7 and 8.
2 brothers.
7 is the brother of the deceased, and 8 is the mother.
He's the wife. There was some problem. I heard this matter. You have filed your affidavit?
Yes, no, sir, we have filed it today. It will vote on the same.
My goodness. You were asked to file the affidavit on 21/10. We can't accept this affidavit. I'll pass an order. Can't accept this affidavit. Pass another order. It has been submitted that an affidavit has already been filed today on by the respondent number 7 and 8. So taking into account the above, this matter again on. We need to finish it off
My lord.
early because everybody is hung on 27th of November at 2 p.m. In the meantime, the petitioner would be at liberty to file reply if any.
That interim
52.
is there, man.
Huh?
Not to disregard
The
them.
same orders after we should continue.
I'll let you. Alright.
Affidavit file,
Yes, yesterday we filed, my lord.
you. District administration has filed affidavit. Chalo, we call the district administration Nagaon. We'll get the district administration Nagaon. We ask has the revenue department file affidavit in this matter?
But interestingly, my lord, I have the copy of their instruction. We have annexed.
Who?
It's a.
This is a case where the state is actually speaking in one voice.
The circle officers written to the additional deputy commissioner revenue, parawise comments of WPC student. I have.
Anyways, revenue has not filed an affidavit direction. It was specifically directed, neither district commissioner Nagaon has filed affidavit. Forest has filed, na?
The foresters.
It has been submitted by Mr. T. Gogoi that the forest department have already filed the affidavit. However, the district commissioner Nagaon nor the revenue department of the government of Assam have filed the affidavit in spite of the specific direction given on 8/11/2024. Pusto. List this matter again on 27/11/2024 at 2 p.m. Pusto. A final opportunity is being given to the revenue department to explain as to how the petitioners would be rehabilitated. In addition to that, the district commissioner shall file the affidavit. File the affidavit as directed by the order dated 8/11/2024. It is made clear that if these affidavits are not being filed by the district commissioner of Nagaon as well as by the revenue department, this court would have no other option but to seek the personal attendance of these officials.
53.
with you, Lordship. Lordship, this is a matter whereby RTI.
Taken steps. What about the steps?
Lordship,
Steps complete?
R2 has appeared, council's name appears.
On number 4.
on
Okay.
the constitution.
Steps being complete. This matter again for admission on 2nd of December.
Obliged.
That safety for it all. Last. Yes. This matter again on. What are you gonna release this matter again on 27th of November 2024. What else can you say? Yes, orders, what are the matters? Yes, what are the important orders?
Order item 138.
What is this? What is this? Why it has come up for orders? We'll have it for admission. Why the matter has come up for orders?
One of the respondent has not been yet served. Even though we have, more than 10 years now.
No, 15 and 17 have filed. Is there any mention in the order sheet that the respondent has not been served? Oh, okay.
Respondent number 27, I think.
What the matter is there?
Otherwise, Lordship may take up for admission.
Affidavit filed. As regards respond number 27, the petitioner has paid for service of the airplane. A paper publication has not been done. Why?
We have told the court, but the court was about to hear the matter, said we not required something.
Hello, we spec out the name of respond number 27. Who is the respond number 20? What are these type of matters? This looks like a second appeal.
Always some person who are not personally agreed with matter.
Matter is pertaining to what?
They have set up as many as 37 stone crusher and other industries in a village.
These stone crushers must have been closed.
No, they're still functioning. They're still functioning. Yes, my lord. Many stone crusher has been closed by.
Yes.
They're functioning. It's a matter of 2014.
How do you know? No, wait. How do you know Surendra Stone Crusher is
They
functioning?
have listened to, they have filed affidavit alone.
Forget about that. I'm saying about Surendra Stone Crusher. 27.
27.
How do you know? If they are running, and if you are running, then why you are not able to serve it? You say that, no, you say that you are going for paper publication because you don't know the address, then it has not been served. Then the service upon the respondent number 27 has not been completed. Full stop. The petitioner, as seen from the Lozima Court's order dated 2/8/2024, the petitioner sought for time for effective service to paper publication. However, no petition in that regard have also been filed. Mr. So-and-so, the learned counsel for the petitioners, submits that he would file application. Full stop. This is a matter pertaining to the year 2014 and 10 year and a decade have passed by. Full stop. Accordingly, list this matter again on 20/11/2024 at 2 p.m. The applications be filed for paper publication by 18th of November 2024.
Hundred 139 to 141.
Where are these? They are also 2015.
Also,
You are agree.
seeking for the refund of the security money also.
Huh?
Default of. Furthermore,
Why have these matters come up? No further affidavit has been received, no further affidavit has been received. Okay, taking into account that the service is complete, leaves these matters for admission after 1 week.
Hundred 42.
Yes, Mr. Gogoi, what is this?
That's contempt, my lord. We have
Okay.
issued
Oh, serious.
the
According to fixes the year, incumbent to ensure the year, the active apply this code by why contempt. Yes, have you filed affidavit?
well, some development is there, well, some.
No. Have you filed affidavits? So we initiate
filed
contempt. Chalo, contempt of post action direction, how to initiate? Initiate the contempt of court. Now we have to ask him to be personally present to hear the sentence.
What has happened, the documents are lost.
I am
We
not
are actually
concerned.
petition to submit the document.
I am not concerned. For that, you file appeal, whatever you think, contempt of court. Now, how to initiate proceedings? We asked you to file affidavit, you have not. So it is seen that by the order dated 4/11/2024, this court directed the present incumbent chief engineer, PHE department, as well as the superintendent engineer, PHE department, Nagaon Circle, to apprise this court as to why contempt proceedings should not be issued against them. What are the names of the names of these people?
Chief engineer Gayatri Bhattacharya.
And superintendent engineer? So you don't know itself.
So that name I have to.
It has been submitted that Mrs. Srimati Gayatri Bhattacharya is the chief engineer, PHE of the PHE department. Yes. Accordingly, Mr. D. Gogoi, who appears on behalf of the PHE department, is directed to inform Ms. G. Bhattacharya, Srimati G. Bhattacharya, to be present before this court at 10:30 a.m. The contempt no video recording. No. We'll at 10:30 on 18th. No. 18th. Personal appearance on 18th. No video conferencing. These type of matters we have to inform about the video personal appearance of Mrs. G. Bhattacharya on 27th of November 2024 at 10:30 a.m. to explain as to why contempt proceedings should not be initiated. Ms. G. Bhattacharya would be at liberty to file, is given an opportunity to file an affidavit in showing cause that no contempt proceedings should be initiated against her, which shall be considered. From here, we can directly, immediately, sentence will pass away. Mr. Gogoi, question is, sentence will be passed immediately when she
since
appears.
the order was to apprise, we have documents to apprise your lordship.
I'm asking you, have you paid? There's a direction to pay.
You cannot pay, my lord. Documents are not there. We asked the petitioner to give his documents. His
Can't help it.
address is not.
You never said all these things earlier. Can't help it.
So, my lord, she has to be present or affidavit both, my lord.
Both. Because immediately we'll see, we'll pass the sentence, we'll immediately ask the police to take her.
My lord. Okay.
Oblige.
43. 143.
Yeah, could you do?
Time has already been given. Your Lordship, there is the order of the Honorable Supreme Court, subject to the decision of the renewal of the RR and the contempt notices has been issued by the Honorable Supreme Court in the identical material. Kindly have Annexure 6 of the reply.
What do you want?
Matter may be heard finally, Your Lordship. Some date may be fixed for the final hearing.
Is this matter for 4 weeks?
144.
Service report may be awaited on respondent number 4.
Hmm?
Respondent number 4, private distribution.
Service is awaited. This is item number
44, 144.
service is awaited for as regards respond number 4. This matter again on 16th of November, December 2024. Interim order custody and reasonable payment.
145.
Service complete?
Service complete, but in this case, service Lordship, there is an order for consideration of service.
I'm asking you, is the service complete?
Yes, Lordship.
Okay,
Petition-
service being complete,
Petition number
this
one
matter for
seven.
admission. On 8th of January 2025. Interim order custody shall continue till then.
It is reportedly further directed by your Lordship on the last occasion, my lord. And affidavit will be replied
File it.
not from my from the state authority. My lord, it is in connection to the Mujib of my lord.
I am not concerned. If the respondents don't file the affidavit, it is their record. I can't help it. This is for orders, madam. This is not for admission, yes. Tell me. 140?
146.
Yes, same order. Very good. Oh, Kali Asin. That matter, hearing is there, na? Where is that matter? Yes, that we'll take it up at 5:30. Wait.
147.
Yes, next 156.
156.
We'll take up 156 later on. This matter after 1 week. 157.
Respondent number 6.
Service complete.
Not found.
157. An affidavit in opposition by respondent number here has been received. Properly even naile ki kyun? Yes, Mr. Mr. Yes, what was it क्यों आया? Service में फिर भी तो बने थे। फिर भी लेते फिर भी लकड़ी पर खाए। Cannot come up for it. Different. तो कहीं से समझ सर्विस किसी लास्ट सारे नहाने और 57 सर्विस में फालतू
and 57.
You have not taken usual steps.
Restart for 3
Huh?
We have taken very strict.
No, no, no. Counsel appearing on behalf of the petitioner. Who said the service upon the respondent number 6 is not complete. So taking into account the above, the petitioner is directed to take fresh steps upon the respondent number 6 by both visual as well as by registered post within 7 days.
158.
Service not complete. This is matter of the completion of service. You are appearing for
107.
1 and 7.
Fine.
Who's going to file an affidavit as regards this?
The social justice and about government.
Are you appearing for them? No.
No. My name is available.
Give your name, dude.
Mine.
Item of 156 here.
Which one? One?
It's a order.
What do you want? I'll have it next week. Keep the date. Not asking you. But there is an effective order to be passed in that. You know, I tell you. Last second. Yes, what item is yours?
147, the hearing matter, main list hearing matter.
Right? This matter has come.
It's for hearing only.
Who fixed?
2014 matter. No,
Who fixed it?
the court on last occasion when,
I fixed it.
no, my lord, on last occasion on 20,
Let that court do it. I'm taking of his matter and partners.
your lordship will fix it with date, my lord, the date next week.
No. Shouldn't have been coming up today. I fixed that matter because it is partnered. He said they were going
This
to
matter
do
was,
it at 5:30.
because on 24/9, when this matter came up for hearing, then, my lord, this is a land when the petitioner's land has been in illegal occupation of CRPF authority. Now affidavit has been exchanged and the government say, Assam government says that the land was not acquired. The CRPF says that it was given to them, but they could not produce any books. So matter was fixed for hearing. So during that hearing on 24/9, my lord, they were asked to, that if you can, what is your stand, you clarify. So no,
Who, before whom?
before Honorable Justice Edi Chaudhary. So the only next, because
It was almost hard.
no, it was not hard. Hard, but they, my lord, last order, any clarification that, because affidavit, my lord,
What's the
Assam,
matter?
yes, 147. Assam government, my lord, says that this land, petitioner's land about 5 acres, it has never been acquired, is in unauthorized occupation of CRPF authority. So, my lord, 2014 matter, my lord, any week, any day next week, my lord. No, my lord, acquisition, nothing, my lord.
He does, if he is on the matter on, he expresses urgency in the matter, he can take. Right. A right, but their rights over the land. According back on 5th of December,
Next week, my lord.
5th of December. I can't finish up these 2 weeks.
On 26, 26 November. Let us take a transfer. Because the petitioners are all 80 plus.
6th of November.
I'm deeply aware.
Yes. Anyway, we bypass the next meeting.
Last item.
Tell me. How did you take care of the other people? Is that the case?
No.
Pertaining to that
Promotion, my lord.
promotion, and that you were not granted the promotion, taking into account the ACRs of 2002,
2003 and 5.
Huh?
2002, 3 and 2005. There's an advance.
They have taken only 2, 3.
No, no, it's 2, 3 and 5 and 6.
No, no, no. See the order, I remember, you have only taken 2.
Our rejection notes is 2003, 5
Kindly
and
see, no, no, kindly come to page 278. On examination of the ACRs of so and so, observe that ACRs in respect of Sri S. Morali is having adverse remarks in the ACR for 2002-3. 14-2002 to 25-8-2002 and 26-8-2002 to 31-3-2002. This is the period which they have not taken 5-6 or anything. So therefore, so the adverse remarks is only taken in respect to that period.
our FCC lawsuit, as per our affidavit lawsuit, it is stated 2002 and 3 and 2005 and 6.
How? No, no, we go as for the selection board. Kindly come to page 278. So how can we take it into other aspect of the matter? You have only taken the adverse comments in this period.
Page
278. There is a page. I gave you an opportunity to be taken up today, subject to you were not ready. 278, you don't have the page. That is the internal page 47. Internal page 47 of the affidavit. Your affidavit. Okay. After the observations which have been made by the learned single judge in the earlier petition, how could he have taken these? Isn't it? How?
As far the adverse entry is concerned, lawsuit, it's a relief lawsuit. I think as far the adverse or remark of the SCS are concerned, lawsuit, it's a relief lawsuit.
So for how long you are, therefore I'm asking you. If a person has an adverse entry in 2002, for consideration in 2010 also, you are going to take it in that manner.
Considered by the
In the meantime, Mr. Counsel, was he promoted? The 2002?
earlier, he was promoted from inspector of factories to senior inspector of factories.
When?
Of the 1999 lawsuit, 10/10/1999, he was promoted to senior inspector of factories lawsuit.
So thereafter, what happened?
Thereafter, Lordship, they are taking.
Even in vague.
Lordship in
No, it's
2000
vague. Your thing is vague. So for all times to come, if somebody has an adverse entry in 1 year, can you say in 1 year, 10 years ago, are you going to look into it?
But the DPC held in 2008 Lordship. That was also Lordship prior to 5 years of 2008 Lordship. We taking into account petitioner was senior most Lordship, but he had negative remarks.
Understood. The court therefore saying that in respect to the next one which you are going to take, you don't, you first you are going to bring and next whenever vacancy arises, you do it. So what happened is that first in 2008 you did not.
Not.
Again in 2010 also you
2010
did
also.
not. How long would a person suffer? Mr. Counsel, there are judgments.
No.
Wherein Supreme Court categorically says that you cannot have these ACS for all time to come like this. You have an adverse entry, okay. 2002, it's okay, but there has to be a, therefore you would see most of the rules. They say the ACRs for the last 5 years. Because those adverse entries has come to an end. A stigma which is attached at one point of time, that cannot be the continuum because that would amount to an unsafe, it would amount to a major penalty.
It shows their biasness also.
So biasness can therefore say from somewhere there are judgments the Supreme Court indicated. Wherein it has the Supreme Court categorically observed. You cannot take like this. And more particularly taking into the observations made by the learned code by the coordinators. These are absolutely, you couldn't have had these. So you find out one judgment today. I would have otherwise because I don't normally take up these type of matters, but I'm saying I know these are their judgments on. Wherein it says that the ACRs for a particular period of time, once a stigma is there, they will continue to have that stigma for all time. Will have means once you put somebody puts a adverse remark, it will have serious consequences. It is more like a penalty. Meaning means you would not be granted any promotion. That too without hearing, without an inquiry. So therefore, and that too you were not given the report. More particularly, you have not been given an opportunity to represent.
They have given it after 2002, 3 and 5, 6 together in the year 2007, whereas the rules categorically says that they have to inform me within 1 month from passing the adverse order.
So therefore, the civil judge held it. That was not in concurrence. Find out what can be done. There are Supreme Court judgments. Find it out. We have it again when
Next thing.
5:30.
No problem. Before that, Lordship.
Before that Lordship. Better Lordship. At 2 Lordship.
Two not possible. Two have fixed many matters. Anyway. You can get that judgment. I'll pass the order. And how will I give you that notional benefits? I am in favor of you, but give me some handle. I cannot, this is absolutely incorrect. But how do I give a benefit now, after a period of 10 years? What is required to be done? I mean to say, when you pass an order, now, order should be such that it can be given to I don't want you to go for contempt unnecessary. Contempt has to be such that yes, you have not done. But when these are very old matters, it becomes very difficult. It becomes a very difficult to do. So, there are various judgments to get, right? How we can do that. The matter being heard at length. Hearing remaining conclusive. Matter again. 21st of November, going autumn.